Mention a lot on division bench review matter, my lord. During pendence of the review petition, both the petitioner and respondent has tried, my lord. Let it be listed, my lord. The proper place admission, let's see.
Petition of the year 2012. The matter has been fixed to fold. It is a non-payment of compensation. It's long payment.
One
My lord,
application,
item number 1, the case may be adjourned to next week.
one matter that rejection of application for extension of R&R benefit that was specifically adjourned to 16/12. State was directly to the instruction. And one criminal appeal that is adjourned to 5 March.
What purpose?
For purpose of bail.
Bail.
LCR already come. And deposition copy supplied to your team.
Mention challenge the lease proceeding initiated by the opposite parties, but now the opposite parties are trying to start the construction.
Give him notice.
My lord, on behalf of my senior J.M. Patnaik advocate, the
Yes.
case may be adjourned to next
Which
week.
are case?
Sir, Gopinath Puhan versus State of Orissa.
You have no patience. It is item number 1.
That's it.
Acha.
Yes. Already.
Supplemental list, item number 1.
Yes.
My lord, on behalf of my
What is
senior,
the case?
my lord, I'm not briefed about the case yet.
You have no power in this case.
Sir, my senior is not.
You got power in this case or not?
What is your name?
My lord, Ayushman Patnaik.
Ayushman
Ayushman Patnaik.
Patnaik. You have
Yes.
not gone through the brief yesterday evening.
My lord, no.
Why?
My lord, I was not briefed as my senior was unavailable.
Yeah.
My
Mr.
senior,
Counsel, senior counsels are briefed. You have to read the brief and brief the senior.
Hello.
Nobody is going to brief you.
my lord,
You yourself have to read the brief.
Even if you come for taking adjournment, you have to go through the brief.
my lord,
You should know how you will develop yourself.
my lord.
So, what are the orders passed? Are you aware about it?
Presumption by the consumer as well as the appellate order has been challenged.
Show him the file. And let him go through it. We'll take up this matter. Government Grants Act of Chief.
Washing point. Washing point. Next time see
You
the
sit
senior
down,
brief for you.
sit down and go through it.
Item 2.
I don't see whether nothing is there. Consolidated cost title not filed. Maybe for yesterday already filed.
Yes.
Nothing is that consolidated cost title not filed. Day before yesterday, we have already filed the consolidated cost title.
Record
We didn't receive the copy of the same. Let them serve a copy. Copy of always without serving, we cannot file the original writ petition we have received. Only consolidated.
Mr. Padi, he says copy has been served, so you ask your clerk or somebody to check.
Consolidated.
They check.
Mr.
Checked it up.
Day before yesterday.
Yes.
Yes.
On 4.
85.
We'll check it up.
Land Counsel for the petitioner submits that consolidated cost title with index has already been filed on 4th of March 2025, and copy has also been served on the Land Counsel for the Union of India. Let the registry place the same on record. Put up this matter next week. Okay. Mr. P.K. Pari along with Mr. D. Gochar, Solicitor General are present. Yeah.
13 तारीख दे दो जो सब
अच्छा हाँ
से दिन रख दो
13 तारीख को दें 13th March 2025.
Item 3.
Definitely non-appeal still RGB complaint.
What is this?
Last time on the
The petitioner's prayer seeking employment has been rejected. That is under challenge at annexure. On 12/9/24, Your Lordship has directed whether in the similar project, anyone has been given employment or not.
He's not interested, we can dismiss it to default because 2 consecutive dates, nobody is there. ବାଧ୍ୟରେ କରିବ ଆଉ କଣ କଣ ପାଇଁ ଫାଇଲ ହେଇଛି କହିକି ଇଏ କରିଦବ ଆଉ।
ଆଜି କରିଦବା। ଆଜି
କୁହନ୍ତୁ ଥରେ ଡେଟ୍ ଦିଟା ଡେଟ୍
second, it has a ଦ୍ୱିତୀୟ date.
ହଁ ଆଜି ଦ୍ୱିତୀୟ
Non-appears for the petitioner on
ଏ ଆସିଲେ ଆସନ୍ତୁ ଆସନ୍ତୁ।
Item 3, my lord, on the last occasion, I took time to obtain the document.
last
Last
occasion you are
occasion.
not there.
Last occasion I was.
It has been mentioned as non-appears for the petition. We have adjourned it to today.
Before that, you had taken time
Yes,
in the month of
before that, I have
January.
taken time to comply with the order,
Yes.
my lord.
Yes.
The Honorable Court has specifically put a question to me that whether any other persons have been extended with the
Yes.
benefit of service under the same irrigation project. my lord. For that, I have asked the petitioner. The petitioner has applied under the RTI because the officers are not providing with the document. For that reason, he has asked for those information under the RTI. I pray for some more time.
For-
It will take some time because the year-old records. So what I humbly pray that instead of, if my lordship permits, instead of fixing a date, I will let the matter be listed when I move.
No. Are you aware that every case is to be adjourned, a date is to be given, and it is to be uploaded in the website?
Then I pray for a longer date.
You pray how much? 4 weeks. How much time do you want? 4 weeks?
Last week of April, any date.
6 weeks. 6 weeks. That's all.
All right, the land counsel for the petitioner. 6-week adjournment. For obtaining instructions in terms of the order dated 12/9/2020.
Submits that he is.
He submits that appropriate application under RTI has been filed for obtaining such instruction. Put of this matter.
ଆଜି ହେଲା Thursday,
All the proper.
ଗୁରୁ 10 ତାରିଖ କି 17 ଏପ୍ରିଲ था।
No, it was
Yes, 8 weeks time କରିକି 17 ତାରିଖ ରଖିଦେବା।
17th of April 2025.
Oh, bless.
Yes.
ସିଏ ପ୍ରେସ୍ 8 weeks କହିଛନ୍ତି ଆଉ। ହଁ ଠିକ ଅଛି।
Item 4.
That report. Put of the counsel that is required. Yes. Reporting at the menu. The reporting at the menu.
The flag 20.
What is this matter?
Says that 783 proceedings that
Cancel
my lease under section 783. Initially, it was cancelled in year 1998. I came before your lordship. Matter was reminded that after that it was again the lease was cancelled. The lease has been cancelled. That is imbue. The grounds of cancellation, my reply is even at paragraph page 8 in tabular form state that what are the grounds they have taken and
lease in question was granted for agricultural purpose.
the lease deed doesn't
And
specify that.
that was not used for cultivation. That was the main reason for which, and you have constructed a house there.
No, my lord, that is a wrong instruction set. That was a outhouse. Now the report says that it's a boundary and some plantation is
No,
included.
you made a
Made a
submission on that
I
day
made
on 3/10/2024 that
there is a house. In fact, there was a outhouse. It was mine.
let us on when it is indicated also candidate supervised construction. Subject location of the plot would He located only in the presence.
What happened to the house?
According to
Outhouse they are being allowed to construct any because
so,
of these litigations.
Who will allow you to construct?
Because it's
Pachari
now
construction
it is
hochundi.
coming to the BDA and town planning, so no plan is being approved because of this litigation.
what is the report of that Tahsildar 18/1/20?
Flag 20.
Okay, so what do you that Tahsildar found?
That
Mr. Pai, kindly give the report.
I'm in
The
possession
last
by
paragraph.
putting a boundary around. The lordship can have the second phrase. I'm reading the last paragraph.
Yeah.
That in obedience to the aforesaid order of the court, the RI Chandrika should notice to the petitioner to remain present on the spot, fixing the date that is 13/1/2025. And accordingly, RI Chandrika, along with the main, proceeded to the spot at Moja, Patharagadia on 13th January 2025 to locate the shoot land. The RI Chandrika spotted by later, as reported by later dated so and so that one Dhirendra Kumar Mohanty, the husband of the petitioner, was present on the spot and produced the sale deed during number so and so, wherein the petitioner has purchased the land measuring so and so decimal out of 1.5 acre, 1.5 plot number so and so, kata number so and so. The suit plot has been identified in presence of the petitioner husband. It is further reported that the suit land was originally Chota Jungle and now surrounded by boundary wall with small trees and shrubs and lime. And lime.
You had filed WPC 15864. Or who had filed that? That is there in your first titles.
That is the previous one. Yes, my lord. That is the previous 15864. In that, the matter was remanded back. Order also I have annexed.
Annexure?
Annexure 6, page 50. And in fact, it is in that order, it is held that 14 years, beyond 14 years, they have tried to exercise the power. Because that the authority has not obtained any. Paragraph 4, may I place one? The original lease having been order dated 26/12/1974 passed by the Tahsildar Council, it was not open to the additional district magistrate Bhubaneswar to initiate the revision proceedings in the year 1998. So moto under section 73 of the Unauthorized Act, as the second proviso, the said sections prescribes after lapse of period of 14 years, no revision under the sections can be initiated. That apart, the opportunity of hearing has never been done.
No, he has considered on the ground of fraud, misrepresentation, material irregularity. On that ground, it has been done. It's not that, and once those things comes, this limitation would not be a bar in entertaining that.
Nothing has been found out to be fraudulent in the implement order. The lordship can have that.
You come to that implement order dated 22/9/2023.
Yes, my lord, that page 31 it starts.
Come to the first the ADM Bhubaneswar has reviewed the matter.
ADM Bhubaneswar has reviewed the matter in Somoto revision section was also initiated in section 73, the Act 1962, and set aside he said lease granted to the Tahsildar had order dated so and so on following grounds of mistake of fact, fraud, misrepresentation, and material irregularity of procedure and illegal infirmity by giving opportunity of hearing to the legal heirs of Hatomaji lessee. It has been ascertained on the inquiry that opposite party of landless, and if he has no profitable means of livelihood in order to be eligible for settlement of the land under the Act and rule in force, proclamation inviting objections has not been properly solved as provided in Rule 55 of the OJLS Rules 1974, nor the concerned GP consulted. Settlement of the government land made without observance of the provisions of section 3(2) of the OJLS Act, which provides that 70% of sums should be settled in favor of SC/ST. The order of priority in settlement of government land as advises on section 3(3) has been violated. The field inquiry report reveals that opposite party is dead and is represented by his grandson Karan Maji, and he stated that the said lease has been transferred. The land is lying vacant. The lease has been granted for agricultural purpose, but the land has not been put to cultivation. Now, none of the grounds stated here are fraud by reason of any act of the petition.
No, please proceed with.
Whereas the applications was made for plot number so and so, the village, the land has been settled with him to plot number 1198 under the same khata in the same village in violation of Rule 36 of the OCLS Rule 1974. Being agreed by the order dated the ADM Bhubaneswar, Rekharani Das claiming to be the subsequent purchaser filed a writ application bearing number so and so, which was disposed of by the Honorable High Court by order number 2 dated so and so, setting aside the impugned order and remanding the matters. Reminded the same remitted back to the matter for face disposal. Of the written statement of the petition on main contention of the appellant is that the lien granted by Hatomaji lease being a poor and landless persons 1.5 acre land plot number 1288 on the khata number 420 Moja Pathargadia through lease WL case number 2893 of 1974. The said lease was granted following due procedure and making inquiry under the provisions. The titular and the lessee was eligible for grant of such lease. Secondly, she has purchased the land from the legal heirs of the lessee and in peaceful possessions of the land. The cancellations of lease is barred by limitations of 14 years. It is to mention here that this is what the contention. So my respectful submission is that nothing has been found out that I have committed any fraud or my lease, I should say, my lessee committed any kind of fraud in obtaining the lease. And the grounds of legal violation I have demonstrated in that table is also non-existent.
No, the lease was granted in whose favor?
In Hottomachi. So I have purchased from the legal heir after obtaining permission of the revenue officer, sub-collector.
One line says it is in violation of section 6A.
Whether that lease deed permits that.
Yes, my lord.
Why the lease deed? Let us see.
The lease deed is not there because it's an agricultural lease that is granted under the lease principle. So under OGLS Act, there has to be a lease deed. But since it is under lease principle, it's only potta. And the potta, ROR.
So lease principle, no rules governing the lease.
No, my lord, that all these rules governing, then I have also annexed in the rate application.
No, there must be some document because it is a government land.
My lord, it's one.
It is a government land and
I'm showing this record of right and Odisha Land Reform Act also states.
No, there has to be some order also.
Then this is the record of right. And it is
record
of right is categorically stated the ପଟ୍ଟା ପାଇବା ଦିବସଠୁ 5 ବର୍ଷ ମଧ୍ୟରେ ହସ୍ତାନ୍ତର ହୋଇପାରିବ ନାହିଁ. And there is a provision under section Odisha Land Reform Act which reverts for a period of 8 years.
Subsequent transfer it is regarding where you have probably mutated.
No, my lord. It is Hottomaji.
Eta Hottomaji. Naga Kanare ଅଛି. Hottomaji. ଆଚ୍ଛା ଠିକ ଅଛି.
The original list.
କେତେ ଦେଲେ?
ତାକୁ କେବେ ଦିଆ ହେଇଥିଲା?
1974.
These documents don't form part of the writ petition.
My lord. Cell deed I have annexed.
ମାନେ ଯୋଉଟା ଏବେ ବଢେଇ ଦେଲେ
that record of right I have.
Copy may be given. Kindly see paragraph 4 of the.
And copy of the permission, my lord. Your lordship can see the revenue officer has also granted me permission at page 43.
Paragraph 4.
Paragraph 4.
Yeah.
there is no page.
The claim of the petitioner on the suit land on the basis of the purchase and possession is not
Paragraph 4 of what?
Paragraph 4, page 33 of the impugned order. The grant of lease itself is bad.
30?
Page 33, your lordship.
Yes.
Paragraph 4. There is no paragraph. The para starts with the claim of the petitioner. The claim of the petitioner on the suit land on the basis of the purchase and possession is not justified, as the land was leasehold land and the lease was granted irregularly. Further, the sale of the lease land was made in violation of the 6A of the Oiler Act. If the lease is bad, the subsequent purchase automatically fails.
Section 6, I'm saying that even if that is 10 years and this transfer is beyond 10 years.
The grant of lease itself is bad.
grant of lease is
And why have you
20.
given permission by the annexure 4? How is the subsequent purchaser to know that the initial grant of lease is bad? You see, the revenue officer has granted permission for sale.
I'll take instruction to that effect regarding the.
No, take
actual
instruction regarding everything, not piecemeal.
Yes, sir. I'll file a detailed counter affidavit to that.
Permission ସହିତ ନେଇକି ଯାଇଛି ଏସବୁ ଏମିତି legally ଦେବେ ସିଆଡୁ permission ଇଏ ତାପରେ
And these are the authority who are in repository of all these documents.
also find out what has happened to those authorities who
Yes,
have given
I'll find out. I'll find out. Take
ଘର
it
କଥା
against
ଭଳିଆ
the
ବାଣ୍ଟି ଦେଇଛନ୍ତି ଯାହା।
It is the report of the Tahsildar Bhubaneswar dated 18/1/2025. The land counsel for the petitioner, you filed it with a memo, has filed the record of right in favor of Hottomaji with a memo. Shall file an interim application for amendment of the writ petition incorporating the ROR filed today.
All documents which you rely on, I'm going to now बढ़ेगी.
Also, all other documents which he wants to rely on for the adjudication of the writ petition, serving a copy on the land council for the state, and the
Next week,
how much time you require
Next week.
to file it? Otherwise, there will be amendment. Consolidated would be filed. Then we'll ask notice to file the council. Otherwise, it would be in a piecemeal manner.
I'm filing in 2 days.
It is your, you do it. How much time you want to tell us?
The matter will be listed immediately after filing on the interim application for amendment.
ना date दे दो. जरा date दे दो.
Mr. Ratho submits that he will file the interim application by. We are giving you time till you say so what time you require by
tomorrow. I can.
No, file by 10th.
By 10th.
By 10th.
By 10th.
List on 13th.
List this matter on 13th of March 2020.
Item 5.
Along with the IF.
Along with the
Item number 5. And then coming to some time to take instruction as to the affidavit filed by the petition.
15/1/2025. What is the order? 13% of the order got the relevant documents which were filed before the ASO in objection case number so and so for recording the name of the petition in the ROR, and he has to file those documents with an affidavit to enforce it. On receiving the efforts at land council, states are obtained as to whether those documents which are produced to the permanent name with this matter so and so. This is that case which Narottam.
Yes, sir.
So,
Identify to that.
there are alternative remedy that has been also held in that Honorable Supreme Court decision. So why will entertain this? You have come against the order. Which order you have challenged? Annexure 1. It was passed by the ASO.
Yes, sir.
The Honorable Supreme Court has stated that we have to first see whether the petitioner has availed the alternative forum or not.
The appeal and revision lies. In this is appeal and revision.
No, that has been. Have you got that Supreme Court decision?
But I have had it.
Not hard it. You should that matter is in the list. Every day it is coming. Narottam Rath aji modhye aschibe modhye. Gautam. Item number 21. Attack 21 of Harkuna.
My lord, I have filed in Commissioner Court.
Just a minute.
As per
The common order passed by the
I have filed.
You see what the Honorable Supreme Court in those batch of cases it has been remanded.
Flag 10.
Whether the power exercised by the ASO under the provisions of Section 12 of the Orissa Survey Settlement Act 1958 were exercised prior to the finalization of the record of rights or at a subsequent stage was not considered by the High Court. Also, whether the aggrieved parties had adjusted their remedies as provided under Section 12A or Section 15B of the Act is also not considered by the High Court.
Yes, ma'am.
The High Court proceeded on the assumption that all the petitioners before the court had leases in their favor in relation to the which no record of right was required to be prepared in terms of so and so. So on these all grounds, so if you are challenging the order, then there is alternative remedy available.
I have filed the case in Commissioner Court.
No, please see your prayer portion, and counsel. You come to your prayer portion. The prayer is.
The petitioner therefore.
The prayer is why the impugned order under Annexure 1 shall not be quashed.
Yes, madam.
That order has been passed by the ASO. So if you have challenged that order in the higher forum, then what is the result?
I have filed the case in Commissioner Court, Bhubaneswar.
Yes.
Commissioner Court has told that it is out of our
no question of this oral, what he said to you, what you done. You have challenged a particular order in which alternative forum is available. So, Honorable Supreme Court has also indicated that. So, once if you will not adjust that alternative remedy, we cannot entertain this writ petition. That is the specific. Please go through that order of the Honorable Supreme Court. We have been asked to verify that before entertaining the writ petition, we have to see whether the petitioner has exhausted all other remedies available under law before approaching the High Court or not.
My lord, I may be pardoned. My adjacent plot, Trupti Misra, she got the order from the High Court also.
Those, are you not aware that all those cases are now have been reopened? That those are on the list from item number 21 onwards. All those cases are in the list.
I have annexed the order, Annexer 7.
Which order?
Is prior to the apex court.
This file, I have also filed this case prior to Supreme Court order, my lord.
So it's all right now.
Prior to apex court, that has to be bound by the apex court. The thrifting is relied by the petitioner that was passed prior to the order of the apex court. So now that cannot stand in the by way of.
No, it's all right. But since that order has come, we have to see that at least whether you have approached the alternative remedy or not. So what is your case? When you approach the authority?
I have approached the Commissioner Court last year, my lord.
No. What is the number of that case? Where is the petition? Why have you not approached this?
I have not enclosed it here.
No. If you have approached already the alternative remedy, if anything has been done in that forum, you are supposed to mention in this writ petition.
My lord, I have cited the order of Trupti Misra also in this my petition because the Supreme Court order was not there at that time.
It's all right. Even if the Supreme Court order was not there, but the fact remains the statute is there or not. So the statute says that against the order of the ASO, which authority were to approach. So if you have already approached the other authority, then you should have mentioned in the writ petition. Why have you withheld that information from the court? Is it not the suppression of fact?
Not against this Annexer 1. Not against the ASO order.
Asking you a pertinent question, Lord and Counsel. You have challenged Annexure 1.
No, I have not gone anywhere for against Annexure.
Why have you not gone anywhere?
Because Supreme Court order was not there at that time.
The statute was there.
Statute was there. Statute gives you a scope to approach a particular authority challenging annexation 1. Our query 2 is that let us say that it was before the Narottam Rath case, but the statute was there. Why have you not approached?
My lord, I may pardon, when my adjacent plot Trupti Mishra got the order, in the same line, I have approached here.
That's not the law.
They have not gone any
So now you know that which is the authority against which
Yes,
this order is to be challenged.
No,
You are not aware.
not
पढ़िकिना सुनता नहीं ऑनरेबल सुप्रीम कोर्ट को ऑर्डर आसंतु पढ़ंतु एवं से स्टैट्यूट पढ़ंतु तापर आसीबे.
And another thing, you have annexed the order in Trupti Mishra as annexure 7, but your index has only 5 annexures.
No, my there. Yeah, consolidated petition.
Consolidated petition तो नहीं, index नहीं इधर.
Consolidated petition.
5 पर.
ये ठीक होता है ये खाली इंडेक्स लिखा है.
Consolidated petition is there.
ऊपर उठे इंडेक्स है.
At page 26.
Consolidated petition
is there.
तापर
Annexure 7
इंडेक्स वाइज इंडेक्स उधर लिखा है. annexure 2 तो लिखा है. हां इंडेक्स सेवटा होती है 7टा 8टा annexure है.
मो इंडेक्स तो 5टा है.
5टा हां
Consolidated petition रे सब होची.
अरे इंडेक्स टा का consolidated रे इंडेक्स टा पेज देखांतो.
Running page 26.
Page 26.
Page 26.
26 हां.
Page 26.
Just under the objection by S. Ratho. Is there?
That Supreme Court order for the county देखते नहीं जोटा चाहिए हम बाहर को टिल करा जो आरोप केस है. हाँ ये सर्वे एंड सेटलमेंट एक्ट का दिन पुलिस
12A of the Act.
Have you got the book with you? ना सेटा भी कहियो पड़ियो. आश्चर्य मानो making mockery.
Settlement.
Against order passed that the preliminary publication of draft appeal lies.
Under section 12A.
An appeal is presented within 30 days from the date of order. Appeal against shall lie every order passed by the sworn so under section sworn so to the settlement officer or to any officer, any other officer especially empowered by the government in their behalf. Then final publication is to be made on 12B. Then 15B is another provision which says division by the Board of Revenue. The Board of Revenue may in any case direct on its own motion, the revision, own motion, on the application of a 15B as if it is small b, capital B is 15B. On an application made within 1 year from the date of final publication under section 12B. 12B the final publication is
already said.
केबे हला If a final publication has been made, that means you have not raised any objection.
We have raised the objection with the Commissioner Court on that case. When the land has come to
Where is your averment that final record of rights have been made in terms of section 12B?
that I have not filed.
Then, because that order, against that order, revision is maintained. These are the things which have been mentioned in that order of the Honorable Supreme Court.
I may
Right?
be
And
permitted to.
that is why the matter was remanded in all those matters which were disposed of, that was remanded.
Mr. Sahu, you are repeatedly referring to the order passed in Tripti Misra.
Mine.
Have you seen that order?
Yes.
What is there in that order? Disposed of in terms of the order passed in Narottam Rath. ସେଟା ପଢିବେନି ଆଉ ଖାଲି ତୃପ୍ତି ମିଶ୍ର ରିପିଟ୍ କଲେ କେମିତି ହବ? ଭଲ କି ପଢିକି ଆସନ୍ତୁ ଦେନ୍ ଆଡ୍ରେସ୍.
I may be permitted to file that order.
ପୁଣି ସେ ଅର୍ଡର
Order am pakhre achi.
ये Commissioner Court what I filed there and what is their
We do not know. We are disposing of that. You have got alternative remedy. You approach that.
alternative remedy.
କହିବାକୁ ପଡିବ, ଏତେ କହିଲା ପରେ ବି କହିବାକୁ ପଡିବ.
Board of Revenue I have already filed and Board of Revenue already rejected.
Where have you disclosed all those things?
ଆପଣ ରିଟ୍ ପିଟିସନ
ଲେଖିଛନ୍ତି?
ସେଟା କାହିଁ ଦେଖିନି ମୁଁ ତ only ASO order କୁ challenge କରୁଛି ସେ
ବାଃ, ଆପଣଙ୍କର ASO order against ରେ ଆପଣ ଯିବେ ବୋର୍ଡ ଅଫ ରେଭିନ୍ୟୁ କୁ ଆପ୍ରୋଚ କରିବେ.
ତା ଲାଗି ତା against ରେ ଯାଇନ.
ବୋର୍ଡ ଅଫ ରେଭିନ୍ୟୁ ଆପଣଙ୍କର
ଯାଇଥିଲି ଯେ ମତେ ମୋର ଏଟା ପଟା କରାଯାଉ ମୋ ନାଁରେ.
ସବୁ ଜିନିଷ ଗୁଡା ଟିକେ କହିବେନି so that ନହେଲେ ଆମେ ଏଇଠି ଗୋଟେ ଅର୍ଡର ଦଉଥିବୁ ସିଏ ଏଇଠି ଗୋଟେ ବୋର୍ଡ ଅଫ ରେଭିନ୍ୟୁ ଗୋଟେ ଅର୍ଡର ଦଉଥିବେ.
You have not approached the against this order of this ASO.
Not approach.
Go to the approach. Look, this writ petition has been filed by the petitioner Snigdhar and Samantray challenging the order passed by the ASO. ASO kodi karo? Assistant Settlement Officer. Kurda, bracket लिख दूं तो bracket rental colony now at Katak Major Settlement Office, Jubra Katak, है ना? While disposing of a batch of cases, Sitan of Unauthorised. In SLP number so and so. In the case of State of Orissa and others versus the Samantray, the Honorable Supreme Court has observed as follows. You quote whether the power page number 6 रे अछि अच्छा सेटा available अछि Supreme Court for order in item number 21 item number 21 Ajira list WPC number 1608 of 2014 रे Supreme Court for order टा अछि, that is SLP number 26551 of 2023 flag 10 रे अछि सेटा देखिबे तार जोर कोट करिवे से मझी पोर्शन को है ना गोटे पैराग्राफ बड़ पैराग्राफ तो सेटा कोट कर दे. Accordingly, all the matters were remanded to this court for consideration or phrase. When you put a pertinent question to the land and counsel for the petitioner as to whether against the order passed by the ASO under Annexure 1, he has approached the appropriate authority under the Odisha Sovereign Settlement Act 1958, the land counsel for the petitioner wants to obtain instruction in that respect. ଆମେ coming week ରେ ରଖିବୁ ନା ତାପର week ରେ ରଖିବୁ ଆମକୁ concrete information ଆପଣ ଦେବେ so put up this matter on 20th of March 2025.
सुप्रीम कोर्ट को ऑर्डर टा टिके पढ़ेबे
Yes.
Item 6.
This item 6 non-appears. Last time also non-appears.
Item 7.
Wait.
से एका टाइप के सब
कौन करें good non-appears.
Item 7.
Right, please, Your Lordship. My Lord, this issue is regarding that rehabilitation scheme appointment. The query from Your Lordship was whether, as per the scheme prevailing then, whether more than one person could have been appointed under the rehabilitation scheme. So, my Lord, I could get my hands on the 1989 scheme. I'm ready with the affidavit, my Lord. I'm filing it by tomorrow. So, Lordship may take it up Monday or Tuesday. By tomorrow, I'm filing. Next week, ma'am. Yes, ma'am. Yes.
Item 8. May I please, Your Lordships? My Lord, this is a writ petition filed by the petitioner aggrieved by the wrong evaluation of the building over the land acquired by the BMC, Your Lordship. My Lord, earlier the petitioner has approached this Honorable High Court in WPC number 19449 2023, Your Lordship, where the Honorable High Court had directed to consider the representation within 3 months, Your Lordship, on dated petition Annexure 4, Your Lordship. That is dated 10th July 2023, Your Lordship. Again, they re-violated, but no inquiry report has been submitted, and they made it the same as it is. But my building was made of stones, but they have calculated it as wooden bricks, Your Lordship. So they had made the calculation as 78,000, Your Lordship.
Section 6 is the order. Eight 723 10/7/23, right?
Are you challenging Annexure 6?
Annexure 6, Your Lordship, page 20, from page 21, Your Lordship.
No, where is that specific prayer in your prayer portion?
There's some issue with the pagination, my lords. I think the last order reflected that.
से last writ petition रे copy paste कर देते हो बोधे
Page
prayer टा।
भूल लीजिए, in fact, my lords, order date 18/2/25 says that learned counsel of the petitioner seeks for an adjournment till next week in order to obtain necessary instructions in the matter and to refile Annexure 6.
Annexure 6 has been refiled, Your Lordship.
Madam, if you are challenging a particular order, that is order dated 16/8/2023, passed by the Commissioner Bhubaneswar Municipal Corporation,
Yes, Your Lordship.
was passed as per the order dated 10/7/2023 of this court in your earlier writ petition. Are you not supposed to mention it in the prayer portion?
Annexure 6 रे actually दीटा order ଅଛି।
এই অর্ডারটা তো পাস ହେଇଛି ନା ଲେଖା ହେଇଛି রিট পিটিশন ର ଅର୍ଡରଟା ପ୍ରୋଡ୍ୟୁସ
index ଟା ଭୁଲ ଅଛି ନା କଣ? ନାଇଁ Annexure 6 ଟା ସଜାଡି ଦେଲେ properly page mark କଲେ but ତା ଦେହରେ index ରେ ବୋଧେ properly ନାହିଁ କାହିଁକିନା ଆମ index says copy of letter dated 18/3 6 Annexure 6 ହଉଛି ଏଟା କଣ ଆମ index ଟା ଭୁଲ ନା ତାଙ୍କର ଭୁଲ କି ଦେଖୁନାହାନ୍ତି ଆମ Annexure 6 କହିଲା copy of letter dated
16/8/23 ରେ ରହିଲା ରିପୋର୍ଟ ପାଇଁ ରହିଲା ଆରଆଇ
ତାପରେ ଗୋଟେ order ଅଛି
ହଁ ରିପୋର୍ଟ ମିଳିଲା ପରେ ପୁଣି ଅର୍ଡରଟେ ପାସ୍ ହେଲା ରିପ୍ରେଜେଣ୍ଟେସନ ଡିସ୍ପୋଜ ଅଫ ହେଲା 23/24 ରେ so the final order that means has been passed
27/2
ଏଟା 27/2 ତ
କି 22/2 ସେ ଯାହା
27/2
ନାଇଁ 27/2 ରେ ମେମୋ
ହଁ
10 ବୋଧେ ହେଇଛି 23 କି କଣ
22 ଲେଖା ହେଇଛି
Looks like 20.
22 ଆଚ୍ଛା
22 ଲେଖା ହେଇଛି
ହଁ 22 23 ଯାହା ସେଟା
ତ
ତ index ଟା କଣ ଏମିତି ହେଇଛି
index prayer ନାହିଁ specific ନାହିଁ
ଆଉ index ଟା କଣ
I have made Annexure 7, that is the representation again I have given to you.
ପୁଣି
no
representation
question of representation. We are not sitting here to dispose or direct for dispose of the representation time without number. You came first time, you said that the representation is to be disposed of. That order was passed and the authority concerned has disposed of the representation and passed the order. So now you have to point out what is the illegality in that order. No question of representation disposal.
It's a Lordship, in the order dated 22/2024, they have told that they
madam
yes, sir.
madam have you
Yes.
referred look at your paragraph 15 you have only stated that opposite party has sent you a letter where is the reference to that order dated by Stui? Where is your averments regarding illegality of the order? What is this? Paragraph 15 देखले annexure हला they are sent by this letter sarla.
You are challenging a particular order that is Annexure 6. You are supposed to mention it that under what grounds you are challenging, and even in your prayer portion it is not there also that you are challenging Annexure 6.
You've just copied the I think the earlier writ petition prayer copy paste. This is not the way. Withdraw and file.
You withdraw it.
I will withdraw it and refile it.
The learned counsel for the what is your good name?
B. Panda.
Your full name, please. Power achi.
Banaja Panda.
Banaja Panda.
Banaja Panda. Ms. Banaja Panda, learned counsel for the petitioner. After arguing some time, seeks permission to withdraw the writ petition to file a better application with detailed particulars. Accordingly, the petition is disposed of as withdrawn, giving liberty to the petitioner to file Best expedition, yes.
Obliged. Item 9.
But my application to obtain the copy of lease deed, my lord, has refused to apply because presently the record is not traceable, my lord. My lord directed to produce the lease deed, my lord.
Lease was granted in whose favor?
Pardon, my lord?
Lease was granted in whose favor?
Usharani Mahanti.
Why lease was granted, or what type of lease it was?
Pardon?
What type of lease?
Homestead, my lord. For homestead purpose.
Under which act that was granted?
Under lease principle, my lord.
Okay.
So,
So it was granted in favor of Usarani?
yes, my lord. Usharani Mahanti.
Usarani Mahanti.
Yes, my lord.
Who are you?
I am the purchaser, my lord.
So unless we got the lease deed, how can we know that whether it permits the lessee to sell the land in your in favor of anybody? Whether that is permissible, or before selling the land, there may be that you are to fulfill certain terms and conditions. So,
So far my knowledge is concerned,
yeah,
there is no such deed is executed by the state government. And there is a only condition, after 5 years of the granted lease, the land
the lease re asile Usarani paile on the basis of a lease deed.
no deed, my lord.
Upon केमती पाइले अपन कहूनाथी गवर्नमेंट लैंड ता ना नहीं गवर्नमेंट लैंड उसाराणी को पाखु केमती आसिला
By virtue of lease, my lord, government settled there.
को कोन मौखिक देई देल नाही तम नियो एटा तो किछि थिबो ना डॉक्यूमेंटरी प्रूफ थिबो जे अपन को लीज दियाला उसाराणी को तो केमती ताउ दियाला
Kindly Anisher 1 million.
ଆପଣଙ୍କର ଡେଟ୍ ଚାର୍ଟ ଗୋଟେ ଦେଇଛନ୍ତି
Anisher 1 million.
ଆନିଶବରାନୀର ଯେ ଡେଟ୍ ଚାର୍ଟ ତ ଇଣ୍ଡେକ୍ସ ଭଳିଆ ହେଇକି ତା ଡେଟ୍ କିଛି ନାହିଁ ବୁଝିବନି
This is not the date chart.
ସପୋଜ ଟୁ ବି
এটা ইন্ডেক্স ভଳିଆ ଲାଗୁଛି ନା এটা ଇଣ୍ଡେକ୍ସ ଡେଟ୍ ଚାର୍ଟ କାଇଁ
ଇଣ୍ଡେକ୍ସରେ ବି ଡେଟ୍ ଥାଏ କିନ୍ତୁ ଏଟାରେ ଡେଟ୍ ନାହିଁ
ତ ଆନେକ୍ସର 1 ଟା এটা কোন এটা উষারাণী
Mahanti below.
ପଟା
This was issued by the Tahsildar below.
Okay, in which year?
70. This case of 73 below.
Good job. 15/7 कौन तहसीलदार को सिग्नेचर लगता है ईयर कोड जଣା पड़े
77 এটা ତ ଦିଆ ହେଇଛି 87 ରେ
87 ने नहीं এটা तो
ଫର୍ମ ଟା ବି 83
टू कॉपी अटेस्टेड है ये फॉर्म टा तो होची 83 रो आपन को 70 फॉर्म नंबर लिखा है देखो ओजीपी फॉर्म नंबर 11 to 1983
there is no document to that effect on page 36 the order impugn there is an observation to that effect by the collector
36
months
yeah
mm-hmm. 23/8/24 order
yes
again
which paragraph Mr.
First paragraph this is an OGLS appeal under section 7A of Odisha Government Land Settlement Act 1962 preferred by the petitioner Harmon Rautre, son of late Vansidhar Rautre at Raisimuli, post Khajuria, police station Brahmagiri, district Puri. Being aggrieved by the order dated 19/7/2002, passed in of WL case number 2301 of 1973. By Tahsildar Jotni under section 3B of OGLS of 1973 रो Westland lease case tag.
कहीं सेटा the document कहीं
that record is not available, my lord. Not traceable.
I filed the certified copy, they have refused me. Presently not received. ଏଇ ଯୋଉ ଡକୁମେଣ୍ଟ ଆପଣ ବର୍ତ୍ତମାନ ରିଲାଏ କରୁଛନ୍ତି annexure 1 so when this document was has been made it is called Jamabandi Register of Continuous Khatiyan Miller. କେବେ ଏଇଟା ହେଇଥିଲା
24/27/87 what is visible on the record
27 ର true copy ଟା attest ଇଏ ଦେଇଛନ୍ତି
copy ଟା ସତ୍ତ୍ୱ minus the second column in the register ଦଖଲ ସତ୍ୟ 0/1975 ଠାରୁ
Had the original lessee filed any application challenging that order?
Pardon me,
Had the original lessee, Srimati Usarani Mahanti, filed any writ application challenging that order?
no, no. Unless we see that, we cannot know that why the land was settled, because it was mentioned that it was for homestead purpose it was mentioned, and the impugned order reflects. But he has not utilized, or she rather, she has not utilized the land for the purpose for which it was settled. On the other hand, she has transferred it to you. Yes. So if a lease, a particular piece of land is settled in favor of a lessee for a particular purpose, and if he wants to transfer it to XYZ, yes, then what are the terms and conditions, what he is required to do, whether it is, first of all, whether it is permissible or not, And if it is permissible, then what should be the terms and condition? She has to comply it before, because the land is not, is a private land, or it has been granted by way of a lease for a particular purpose. And if you want to transfer it to anyone else, then there must be some terms and condition. If whether that terms and condition has been fulfilled prior to transfer, or simply he has executed a sale deed in your favor.
In pursuant to Annexure 1,
Your right flows from that Usarani Mohanty,
yes, my lord.
right?
Yes, my lord.
So if Usarani Mohanty cannot do it in accordance with law, or she has to do it only after fulfilling certain terms and condition, and which she has not complied with, then that goes to the root of the matter.
Well, only condition imposed under Annexure 1, within 5 years cannot be transferred the land. Column 10 and 11 below. ପଟ୍ଟା ପାଇବା ଦିବସ ଠାରୁ 5 ବର୍ଷ ମଧ୍ୟରେ ହସ୍ତାନ୍ତର କରିପାରିବେ ନାହିଁ. This is the only condition imposed in the
ଆପଣ କେବେ ସେ ହସ୍ତାନ୍ତର କଲେ?
Pardon?
ଆପଣଙ୍କୁ ଯୋଉ ରେଜିଷ୍ଟର୍ଡ ସେଲ୍ ଡିଡ୍ ଟା କଲେ,
ଆଜ୍ଞା,
କେବେ କଲେ?
87.
ତ ଏଇ ପଟ୍ଟା ଯଦି ପାଇଲେ, ପଟ୍ଟା କେବେ ପାଇଲେ? ପଟ୍ଟା ଯଦି ପାଇଛନ୍ତି 87 ରେ,
ପଟ୍ଟା ପାଇ 92, 92 ମିଲ.
ହଁ,
ପଟ୍ଟା 92 ମିଲ.
କିଏ?
ପଟ୍ଟେ ଯଦି ପ୍ରେଜେଣ୍ଟ ପିଟିସନର.
ନାଇଁ ଉଷାରାଣୀ କଥା. ଉଷାରାଣୀଙ୍କର ଯଦି 87 ମସିହାରେ ସିଏ ପଟ୍ଟା ପାଇଲେ,
ସେଇଟା ସାର୍ଟିଫାଇଡ କପି.
କେମିତି ଜାଣିବ ଆପଣ ଏଇ ଯୋଉ କଣ୍ଡିସନ ଟା, ପଟ୍ଟା ପାଇବା ଦିବସ ଠାରୁ 5 ବର୍ଷ ମଧ୍ୟରେ ହସ୍ତାନ୍ତର ହୋଇପାରିବ ନାହିଁ? ଏ ଡକ୍ୟୁମେଣ୍ଟ ଟା ଦେଖଉଛି ଦି ସିଗ୍ନେଚର ଇଜ 27/4/1987.
That is
So,
copy below.
certified
copy.
Huh.
The officer was issued the certified copy below.
All right, but you are to take government when he got the patta. If such a condition is there, then when she got the patta, Usarani, because the stipulation is that you cannot transfer it within 5 years. Your registered sale deed is of the year 1987.
Yes, my lord.
So if Usarani got the patta in 1987, she could not have transferred the land to you, right? So you have to make a specific averment to that effect in the writ petition, that when she got the patta.
And your lease, your registered sale deed also give that. Sometimes some averments are there in the sale deed. Have you given us a copy of the sale deed?
Yes,
Sale deed kahin apanଙ୍କର?
Annexure କରିଥିଲ.
Kahin?
Page 16.
ହଁ, ସେ ଏ ବିଷୟରେ ଲେଖା ହେଇଛି, ସିଏ କେବେଠୁ ପାଇଲେ?
Page 60.
16/16.
Sale deed. ଆଚ୍ଛା.
ଉଷାରାଣୀ ବିଷୟରେ କଣ ଲେଖିଛନ୍ତି ଆପଣ? ସିଏ କେମିତି ପାଇଲେ? କୋଉଠି ଲେଖା ହେଇଛି? ସେ ଦଲିଲରେ?
ପରମିଶନ ନିଆ ହେଲା, ସେ ଗୋଟେ କଣ ଲେଖା ହେଇଥାଏ?
ହଁ, ସିଏ କେବେ ପାଇଲେ ତାର?
No date has been mentioned below. ପଡିଆ ନଥି case number has been given.
Wait.
But date is not given below.
ଏଟା ଲେଖା ହେଇଛି ଯେ ଭୁବନେଶ୍ୱର ତହସିଲଦାରଙ୍କ ଠାରୁ ଇଜଲାସରୁ, ଏ ଯୋଉ ସେକେଣ୍ଡ ପେଜରେ, ପେଜ ନମ୍ବର ହଉଛି ଏଟା କେତେ ହବ? ସେକେଣ୍ଡ ନାଇଁ, ସେ ଫାର୍ଷ୍ଟ ପେଜ ଟା ତ ସେ ପାର୍ଟିଙ୍କର ନାଁ ଗଲା, ତାପର ପେଜ ଟା ଗୋଟେ ଅଛି ସିଗ୍ନେଚର ଭଳିଆ, ତାପର ପେଜରେ
Page 18, I think.
ଏଟା 18. ହଁ, ଉପର ପେଜ ଟା ଲେଖା ହେଇଛି 34 ଲେଖା ହଉଛି।
ଥାନା 40
34
34
ସେଇଠି ଲେଖା ହେଇଛି, ଦେଖନ୍ତୁ 1 2 3 4 5 6 7 8 लाइन रे आसुन टॉप रू भुवनेश्वर मुकाम तहसीलदार को इजलास रू पड़िया नथी नंबर 230173 नंबर हुकुम सुआंसो
हुकुम मुताबक दाखल खाता नंबर 440 रू
हाँ
लीज
लीज
सूत्रे
सूत्रे पट्टा पाइथिबा उक्त वृत्ति को आमे विक्रेता चाष बाद पाई सरकार को ठारू 10 वर्ष मध्य लीज सूत्र रे पट्टा पाई नाहु उक्त वृत्ति सुआंसो अंतर्भुक्त नुहे
OLR ଆଇନ ର
कोयला
6 କ ଧାରା ଅନ୍ତର୍ଭୁକ୍ତ।
अच्छा
रे नुहे
ଆଜ୍ଞା।
हाँ अंतर्भुक्त नुहे
बट प्रॉब्ली कैंसिल ହେଇଛି ଯେ परमिशन ନାହିଁ ନା ସେଟା ପୂର୍ବ କେସ ରେ ଥିଲା ୟା ଧାରେ
एई कि
permission
हमर गृह खर्च निमंते टंकार रो जरूरी आवश्यक तापर देइछि से केबे नाही आदिर पट्टा
ନାହିଁ ବୋଲି କହୁଛି ପରା
नहीं केबे सी पट्टा पाइला से जोटा को रिलाय करछंती लीज जोटा जो अनेक्सर 1
लीज सूत्ରରେ ପଟ୍ଟା ପାଇଥିବା ଉକ୍ତ ଆଚ୍ଛା
लिखि दे केबे किंतु पाइला लिखि ना
ସେଇଠୁ 10 ବର୍ଷଟା ଇଏ ହବ
तो तांकु जो पट्टाटा मिली थिला से पट्टा कहीं से पट्टार एटा होची गोटे कॉपी आपण बाहर करछंती 1987 मसिया रे अनेक्सर 1 टा एथुर किसी जणा पडुनी ना तांको पट्टा पाइबा दिवस केबे
कलेक्ट की डेट
हाँ कारण इफ यदि 5 वर्ष टपी जाइथिबो देन दैट वुड बी दैट गोस टू द
नहीं record full or at least state council direct to produce the record full of the easier and better for better application
आपण तो मागिले सेठी नाही थिले तो आनी देई थांदे थोड़ा सब आपण जेतेबेले किणिले ताठू सब जिंस रखिबा कथा कॉपी आपण पाखरे
तहसील
से
बिल्डिंग
जम
ताकर सब रेकॉर्ड शेयर बिल्डिंग जाउची तेणु से मध्ये रेकॉर्ड बर्तन
ନାଇଁ ନାଇଁ
बाहर
ସାର୍ କହୁଛନ୍ତି ଯେ ଯେତେବେଳେ ଜାଗାଟା କିଣିଲେ ସେତେବେଳେ ଗୋଟେ କପିଟେ ରଖିଦେଇଥାନ୍ତେ ସତରେ ତାଙ୍କର ପ୍ରପର କାଗଜ ନଥିଲେ ବି ବିକ୍ରି କରିଛି କି ଆପଣ ବୁଝନ୍ତୁ
ए गोटे जमी को 5 थर बिक्री हो जे जाउची ए 5 जण लोक आसिकिन कहबे हमकु म्यूटेशन करी हमर रेकॉर्ड करो
ତାପରେ ପେଷ୍ଟ ହଉଛି ଲ୍ୟାଣ୍ଡ ଆକ୍विଜିସନ ବେଳେ ଆମକୁ ପଇସା ଦିଏ ଉକ୍ତ ବିକ୍ରୟ ବୃତ୍ତି କିମ୍ବା ତହିଁର କିଛି ଅଂଶ ସେଥିରେ କୌଣସି ସମୟରେ ଖଲିଫଙ୍କୁ କିମ୍ବା
लिखुन the Land Counsel for the petitioner has produced certified copy in CA number 8073 dated 19/1/2024, which indicates that though the certified copy of the order sheet of WL case number 2301 of 1973 has been applied for, but after thorough search of the record section, it was ascertained that the said record is not presently traceable. The certified copy is taken on record. The Land Counsel for the petitioner submitted that the petitioner purchased the land from one Usarani Mahanti by way of registered sale deed. Dated kete hai? Say sale deed dated na?
29/4/87.
29/4/1987. And the lease patta, which has been issued in favor of the said Usarani Mahanti, issued by Tahsildar, is annexed to the writ petition as Annexure 1, which indicates
Jamabandi register.
what is it?
Jamabandi register.
Jamabandi register.
Annexure 2 whether.
The Jamabandi register. Jamabandi register has been annexed to the writ petition as Annexure 1, which indicates that the said Usarani Mahanti cannot transfer the land within a period of 5 years from the date she got the patta in her favor. However, the averment is absent in the, there is no averment in the petition as to when Usarani got the patta. The Land Counsel for the petitioner seeks some time to obtain instruction in that respect. Put up this matter केबे रखियो अपन केबे पट्टा पाइले आपण आनी के उसाराणी बचिजन ना मरले ना से इनफॉरमेशन भी नहीं
अच्छा रिट फाइल करथिले कि नहीं पछरे ओटा रिट मिलुजी जे सेटा तांकर कि नहीं जानी होनी सरणी मानती ऑफ द ईयर 2002
Which file?
और मिलुजी
मुझे जे जानी होनी एटा सी कि नहीं चेक कर देला हो बता नहीं माने जानी था
कवर ये प्रोसीजर मैंने
हां
बस हस्बैंड ना रिगास्ट
हस्बैंड नॉट आसन
खाली
सेटा में डिटेल दो न से कल दा नॉट आसी लिखाई थी गोटे जगह रे कोन टीटी परमिट बट सब्जेक्ट मैटर भूल लिखले भी सेटा आसी
6 weeks time put up this matter on Yellow Show
2 weeks or 3 weeks कितने दिन तक
27th of those 27th of March 2025. The Land Counsel for the petitioners have also filed a date chart by the next date, giving copy to the Land Counsel for the state. This is not the date chart which you have filed. एटा होची Annexure 1 series empty date chart आगे date टा रहिबा पटे एटा कोन हेची से date रे अपन देबे yes yes
Item 10.
Please, my lord. My lord, here the petition of the landless scheduled caste person applied to settle the land by the Tahsildar. His representation is pending. Let a direction be issued to dispose of the representation by Tahsildar.
what representation
To settle the land in favor of the landless person. Yes. My lord, divide annexure 2. OPLE proceeding has been initiated, which also proves that I am also possessing the land. So applied for the settling the said land in my favor, which is also dwelling house constructed over the same. Let a Tahsildar will take a decision within a stipulated time, 2 months.
Application form is annexure 2.
I will also file the yes.
No,
Huh?
it's 20.
20.
Page 20, I believe my lord is the application.
Yes.
20.
20, sir.
20 টাতে কি না 19 পেজ পর্যন্ত ଅଛି
20 କିଛି ନାହିଁ
Sir.
ମୋ record my record
ଆପଣ ଗୋଟେ ଦେଇଛନ୍ତି ଆମକୁ ଦେଇନାହାନ୍ତି
କଣଟା ଦେଇଛନ୍ତି ଦେଖିଲ
Same.
ଆମକୁ ଦେଇଛନ୍ତି ଗୋଟେ ଏଇ ଯୋଉ ଦିଆ ହୁଏ ଓପିଏଲ କେସ ରେ ଆରେ ଆମର ତ ନାହିଁ
এটা তো নাই এখানে application না
না writ petition is copy of the representation 17 ରୁ 19 that is the how can we see page 20 writ petition হচ্ছে 17 ରୁ 19 annexure 2
additional document
ଏଇ ତ ଏଇଠି
ও সেটা ওটা দিয়ে দিবে মেমো
সেটা আমি writ petition না
The document be filed by way of an additional affidavit.
Section 12. 12 OGLS Act. Orissa Government Land Settlement Act, Section 12. No, the encroacher can file because he has proved the possession because the possession he is possessing the land without any objection, sir. Without any objection, he is also possessing the land. Now they have converted the to a dwelling house area. Now OPLE Act means he can also evict him because that is unauthorized occupation. OPLE means Prevention of Land Encroachment Act, the unauthorized occupation. Section 10 and 12 both. Only my lord, sir, Tahsildar to take a decision.
OGLS ରେ କରିଥିବେ ନା
ତ OGLS ରେ apply ହେଇଛି।
ହଁ ସେଇଆ କହୁଛି ପଚାରନ୍ତୁ କୋଉ provision OGLS ରେ
ସେଇଟା କହିବ ବୋଲଟା ଦେଖି
ଜାଗା ଅଛି କି ନାହିଁ କିଛି ଦେଇନାହାନ୍ତି
proceeding
sir
says that settlement of land in case of encroachment of more than 30 years.
my lord
Says that there is courts of any proceeding instituted under section 4, 6, 7 and 8 against any person unauthorizedly occupying any land. It is proved that such person that there has been an actual and continuous and undisputed vision of the land for more than 30 years.
sir more than 30 years I have also possessing the land more than 30 years and he has also that is appeal.
Appeal officer shall give the department the state government to with the land property scope of all these things then it can be settled. So what is your case? This is the only provision which is available under the OPLE Act for settlement of the land in case of encroachment.
Yes, that is encroachment. They have also initiated a proceeding under OPLE Act against me that I am encroaching the land. Sir.
Of more than 30 years.
Yes.
And it should be also actual position.
Physical position.
Continuous and undisputed
occupation
Yes.
for more than 30
Without any objection. Yes.
days, this provision would be
Sir, that should be inquired upon. That Tahsildar has to inquire the matter.
giving that in the application.
With my lord's with my lordship's yes. Only no, that I will that application I have given. If it is required, I also file another application there with that. Taken off 1 week after that. Taken off next week, then I will satisfy.
Format for submitting a application.
This is the format, sir. That application which has not been annexed, but my learned friend also showing that that is the format. That I have stated the annual income, caste, family members, everything. No, that application though. Again. The difficulty is my lord. This is one. This the brief is one of my friend. That is all. But sir, but say nahanti wortan somewhere else. Sir, taken off next week or
Person has been such occupation of the land as opposed to 30 years. He may order the settlement of the land. So government for a permission we have report of the they were in actual continuous and undisputed occupation for a land for 30 years. Then
there should a public notice is required. My lord. I'll satisfy taken off my lord next week. I'll satisfy.
Yes.
Item 11.
The research assistants were inquired.
That order of the High Court, which has been accepted before the Honorable Appeals Court. I have already e-filed yesterday. I'm giving hard copy for the time to the lordship that has not been reflected. The tribunal has referred that order passed by the Procedural kindly see.
Yes, just a minute. Let us go through that order.
Any place it?
Please, please. 3325 order.
Yes, sir. The hard Mr. Rahana and the Senior Common Counsel are appealing for the Union of India. The petition has been filed by the Union of India, others challenging the order dated 14/12/2013, passed in way number 570 of 2017, which was filed by the opposite party, Lingaraj Nanda, and the same as disposed of Honorable Sri with the original application filed by one Madan Mohan Patnaik in way number 206/00528 of 2017. From the operative part of the order, dated 14/12/2023, it appears that the learned tribunal seems to have allowed the original operation taken in account. The order passed in way 528 of 2017. It has, however, been observed that the direction in the concluded paragraph shall be carried out based on the final outcome of the WPC number 25633 of 2020, which is subject before this court. So, when the Senior Counsel appearing for the Union of India submitted that the said of WPC number 25633 of 2020, which was filed by the Union of India, was dismissed by the Supreme Court. However, the Union of India has appealed the Supreme Court, and the SLP is sub judice, and there has been an order of stay of operation of the order passed by the International Tribunal. And if the matter is taken up on the 6th of 3 to he will file the copy of the order passed in WPC number 25633 of 2020. Also, the copy of the order passed in the Apex Court, Supreme Court in SLP. So, I have that as giving back. Yesterday, I find that looking says that.
It's all right. So now, what can be done? We have to wait.
That is the answer. The batch of the cases, so that all have to settle.
Right, that's right. That SLP number is there are
two SLP has been pending. You also may kindly see at page 8.
8.
8 is Susan Misra. That has been referred there.
Right. That's all you would have.
In this order, another SLP has been reflected. That has taken up anonymously. Subsequent order. That is Union of India orders Arunjyoti Sahu. That is also carried out to Supreme Court from Honorable High Court. Our House. Both has been taken and the order has been passed.
Mr. Biswajit Maharanal and Senior Counsel appearing for Union of India has produced the order passed by the order dated 9/9/2024, passed by the Honorable Supreme Court in SLP number 388043 of 2024, which has been filed challenging the judgment and order dated 23/4/2024 of this court, passed in WPC number 2563 of 2020. So also order dated 6/9/2023 in SLP number 27805 of 2023, challenging the judgment and order dated 29/11/2022, passed in WPC number 13897 of 2017, passed by this court. And in both the matter, there has been interim order has been passed. And the operation of the order of this court has been stayed. Just you have filed an order with the affidavit, with the affidavit of the Deputy Chief Personnel Officer, which is taken on record. The counsel for the senior panel counsel seeks for an adjournment for, let us say, 4 weeks to apprise about the status of those two SLPs which are sub judice before the Honorable Supreme Court.
And that order is the outcome of that SLP will be
Right. That is, at least this matter. I pretty lot of you don't vote at the
it will be reflected in the order. It will be. It will also be reflected in that order. Subsequently, several contempt petition has been filing. You will also be refer that will be whatever the outcome of SLP will be.
Obviously, we have stated that this has anybody has filed contempt petition.
That which has been
no, if such situation comes or if anyone filed the contempt petition, we will do, because the order has been stayed, so there is no question of filing contempt petition now.
Item 12.
Application is also directed to verify whether it's any provision for the specific minors before the appropriate authority. And I'm verified minors, that is as per the Act minors, section 64. As per the section 64, the petitioner filed a complaint application before the collector matters. And the collector is the appropriate authority to refer the matter to the competent authority matter, that is the district judge of the concerned district matter. But which has not been referred, though it has been time stipulated within a 1 month manner, the collector should refer the matter before the complaint.
So if he has not referred, then the reports is available under 64 also. You have to directly approach the authority, the district judge.
That has not been done.
So that is to be done by you. If the matter has not been referred, there is a provision that you have to directly approach. So that the district judge is to direct the collector to refer the matter. So,
and the complaint petition filed by the petition is also not proper format. Once I am at liberty to file a petition before the collector in proper format, ventilating.
You want to withdraw this writ petition?
Yes, my lord, sir.
All right. What is that period we see stipulated for filing that 64 petition?
That is 6 months, within 6 months before the final order passed by the collector.
I think that is extended, it is 1 year.
6 months or 3 months?
6 weeks.
6 weeks,
6 months.
6 months?
Ma'am, 64 Any person interested who has not accepted the award by written application to the collector require the matter to be referred by the collector for the determination of the authority.
To be
Collector is to make the reference within 30 days, right? Provided further that if the collector fails to make such reference within the period specified, the applicant may apply to the authority, mean the district judge, as the case may be, requesting it to direct the collector to make the reference within a period of 30 days. Right? The application shall state the grounds on which the objection of the hours also, provided every such application shall be made if the person making it is present or represented before the collector at the time when he made the award within 6 weeks from the date of collector's award. In other cases, within 6
collector
weeks.
under section 21 or within 6 months from the date of the collector's award.
Provided further that the provided further that the collector may entertain an application after expiry of the said period within a period of 1 year, if he is satisfied that there was so the land counsel for the petitioners seeks permission to withdraw these petitions to approach the appropriate authority in accordance with law. It is for claiming higher compensation amount for the acquisition of the land. Accordingly, the petition is disposed of as withdrawn.
Because the valuation report is submitted by the petitioner, the awarded amount is much less than the benchmark valuation values. As per the annex of
I'll find that application.
Item 13.
8 pages lordship. Lordship, kindly see the last order passed on 4/3. Lord, inadvertently, I have mentioned the wrong name of the opposite party number 2 in the first title. In the meantime, I have already complied your lordship's last order. Now, the present case is relating to the land acquisition dated back to 2004. My lord, after the acquisition.
It is now, it is Lingaraj area.
Lingaraj area, my lord. That is the correct one, my lord. Now, after the land acquisition proceeding, my lord, the petitioner has already got the compensation in lieu of his land and structure and also got the rehabilitation assistance. Only the petitioner's grievances, the resettlement benefits, he is yet to take from the authority. That is the only submission he has made before the authority under Annex 4. You know, Lordship, find it at page number 26. Has categorically stated.
So you want this representation to be disposed of?
My lord, they have not yet.
First record certified population not achieve.
Now it is okay.
He's given that counsel.
Corrected first item. Listen, the land counsel for the petitioner has filed the corrected first title. The petitioner has filed this writ petition for a direction to the opposite party to extend so on so forth. They are pushing. Land counsel submits that highlighting the grievances of the petitioner, representation has been filed before the opposite party. Number 2, the General Manager, Lingaraj Area, Talshed, on 29/4/2024 by Danish 4. But no action has been taken there. Therefore, the appropriate order may be passed directing the opposite party to consider the representation under Annexure 4 in accordance with law. When counsel for the state has no serious objection, without expressing any opinion on the merits of this case, it is ordered that counsel dispose of 3 months on the date of production of the certificate of appeal, and it is to be communicated to him within 2 weeks.
Lordship, I only indicate about Annexure 5 because I have filed Annexure 5 as similar persons in the same village have got the benefits only on lieu of this resettlement.
If necessary, personal hearing shall be afforded to the petition. Upon Seudako, next.
Item 14.
The petitioners is in possession of the scheduled land of the deity, Jagannatha Mahaprabhu, is at Puri, for last, my lord, 50 years. So after the judgment of the Supreme Court, that which was prospective in nature, 2015, it was delivered. The land shall be settled subject to verification of the Sabik and Hal. So present issue is that, so Annexure 7, page 34, the concerned Tahsildar, they are initiating the mutation case. So it was earlier decided in the similar case by the Honorable Court, taking reference to Annexure 9, page 37, that mutating authority has no power. Only the revisional authority, Commissioner, Consultation and Settlement, page 37, Annexure 9. Because we have to adduce some evidence, my lords, showing our tenancy right. Page 37, paragraph 4. It has been brought to the notice of the government that in some tahsils of the state, mutation applications are being entertained from the parties on the basis of Sabik record of effecting changes in the current record of right. Such applications are not entertainable under provisions of Odisha Mutation Manual 62 and should therefore be summarily rejected. It has been brought to the notice of the government that after entertaining such application of Sabik Hal comparison of the map are being made to make changes in the record of right. Such practices should be discontinued forthwith. It has to be remembered that not only the Tahsildar has no scope to entertain such application, but also entertainment and disposal of such applications are without jurisdiction and illegal. So, in terms of Annexure 9, violating the direction of the government.
No, mutation case has been initiated. What is this representation?
Yes, representation to the chief administrator.
Yeah.
So, one issue is decided, same, we will, because similar order. The Tahsildar has no power. So, the revision,
you have received a notice in the mutation case.
Annexure,
so if you have received a mutation case notice, you are supposed to appear before the said authority, and you can say that this mutation.
Yes, madam. I mean, this previous order ni dekhi out the case place similar. Say large number of cases are initiated by the concerned Tahsildar. Same. This prayer is also same. It's a by repetition in the nature of prohibition that Tahsildar has no authority and jurisdiction to entertain.
So it is stated that this order, which has been passed by another division bench, there you withdraw the writ petition because the alternative remedy is available before the Tahsildar.
Annexure 9.
Yeah.
I was placing with your lordship. Tahsildar has no jurisdiction, and the entertainment of the application is also without jurisdiction and illegal.
So why are you not approaching it? The authority.
My lord.
Why have you come again to this court? Why are you not approaching the authority? In one case, it has been passed. You can approach the authority that this mutation case, initiation of the mutation case, is not legally sustainable.
Sustainable.
Yes.
ठीक है रेमेडी कौन था देखो तो तहसीलदार विद्रोह कर लेता पर बच कर लेता कौन
उधर
एटा और
फिर आओ the case.
नहीं एटा हल्ला क्या बेटा विद्रोह कर ले और लास्ट वाला था विद्रोह
সেটা সে কনসিড করিগলে ମୁଁ ଏଇ
विद्रोह कर ले
ନୋଟିସ୍ ପାଇଲା ପରେ ଫାଷ୍ଟ ଅର୍ଡର ଟା
हां एटा विद्रोह कर ले
ଏଟା latest order.
अच्छे केस है अगर स्टे ही कितना तापर विद्रोह हो गला
ସେ କନସିଡ୍ କଲେ ଯେ ଇଟ୍ ଇଜ
It's withdraw.
ଇଟ୍ ଇଜ ଏନ୍ ଏରର
Withdraw. So he has to approach the.
I will approach your lordship observe OP number 5 तहसीलदार OP number 5
ये तो विद्रोह करे हम से विद्रोह करे
The land council for the petitioner seeks permission to withdraw the petition to seek appropriate remedy in accordance with law. Accordingly, the petition is disposed of for the withdrawal.
my lord may I pray ये जो the documents placed before lordship also ଟିକେ annexure 9 sorry I was placing ସେଟା ମୁଁ ସେଇ order ରେ ଅଛି annexure 9 page 37
Will not say observe anything in a withdrawal writ petition. Will not observe. खाली लिखी देवे एटा कोन पे फाइल हेतला रीटा.
प्रयास टा कोड
सर्टिफाइड कॉपी
एटा you want certified copy नहीं तो
सर्टिफाइड कॉपी रिटर्न मागु जनता
नहीं
ना कौन को
certificate copy ମୁଁ ଦେଇଛି
instruction टा लिखियो ପାଇଁ जो connection. No, it's not. Yes, next.
my lord may I pray ସେ ଯୋଉ annexure 7 ଯୋଉଟା କୁହା
Will
ହେଇଛି
not write anything on the merits or will go. You have simply you said that let it be withdrawn. We have passed the order. That's all. Yes, next.
Item 15.
May I please approach? In this writ petition, the petitioner is challenging the enforcement by the opposite party, National Highway Authority of India. The fact is that the land was purchased by the father of the petitioner who was died in the year 2023. Annexed the death certificate, Annexure 1, running page 9. After such time, the petitioner filed an objection before the collector, opposite party number 2, Sundargarh Mela, that she clearly mentioned that his father was not aware about such encroachment by the government matter, for which the opposite party number 2 issued a letter for a personal appearance under Annexure 3, running page 26 matter, mentioned one land use. Well, also kindly have a glance. Running page 26 is mentioned in Khata number 101 by 72, plot number 1019 by 1303, area acre 10 decimal, 110 decimal matter. The lordship kindly have a glance. The gazetted notification under Annexure 2, running page 12 matter, published in 12th November 2024, page 16, in serial number 93, 94 and 95. 3 number plot was there, my lord. 1019 by 1252 and 94 1019 by 1298 and 95 1019 by 1303, my lord. Area, my lord, mentioned is 1 acre 65 decimals and 61 decimals and 099 decimals acquired by the NHI is 43 decimals in 92 93 column and 94 column 24 decimals and 95 is 4 decimals. But in my repentation, I have in my objection, your lordship kindly have a glance. Annexure 5, running page 30, my lord. 7/3/2023. I mentioned the entire land, my lord. But this the opposite party number 2 issued only one notice to me in Annexure 3, running page 26, and Annexure 4,
Annexure 3, 26.
26, one mentioning one land. This is
which land was mentioned? Plot number
1019. 1019 by 1303.
So 1019 of the first was mentioned.
First was mentioned.
The two other has been left out.
Left out, my lord. But they are not. After that, they have issued notice to me in several dates. Several dated, and I have lastly I have appeared before the opposite party number 2 on 24/5/2023, and I have raised my objection, but till then they have not
communicated the order. Again, I approached the opposite party number 2 on 26/12/2024, my lord.
Annexure 6.
Annexure 6, my lord. Mentioning the entire fact that my father was not aware about the encroachment published in the newspaper, and they have mentioned the wrongly that one land is mentioned in 3 acre and occupied by the opposite party 1 acre 0.665 decimals, my lord. But they are mentioning 1 acre. They are not taking my entire land. They are only taking one land, but published in 3 lands, my lord. The entire land, but acquired, they have started working, widening the NH 143H, my lord.
To wish to appear for the National Highway Authority.
My lord, wrongly they have done secretary. I just gone through it because they didn't serve the copy. Wrongly they mentioned secretary NHA. The National Highway Authority of the secretary government of India no role to play. They should impede the chairman or the regional authority. Here this officer of the National Highway Authority can party because this ministry has a different rule. The NHA have a different. They wrongly mentioned and in serve copy. Now I examine from this.
No, it's not that. So if 3 plots have been acquired, but
how can they go?
They have left 2 plots.
Yes.
Only notice has been issued in respect of 1 plot. That is his grievance, and he has brought it also to the notice of the authorities.
Yes.
But
the sub-collector is the competent authority to decide all this. The sub-collector of the concern, he is the sub-collector is a competent authority to educate the same because basing on the notification, he is now sub-collector come CLA, Land Acquisition Authority, that is CALA.
अपन खाली सब कलेक्टर लिख दीजिए.
He is the sub-collector come Pancus come CALA. NH 143.
Obtain instruction because this petition has been filed by Resma Dumdum.
I don't know sub copy.
ଆପଣ
କରିଛନ୍ତି NHU କରିଛନ୍ତି ମୁଁ ଦେଖିଲି
ପକ୍ଷଟା ଚେଞ୍ଜ କରିଦିଅନ୍ତୁ ତାହେଲେ secretary କିଏ ନାହାନ୍ତି
you do one thing, you change the opposite party number 1 and the proper party ku apun implead kar diyantu baki state ku you opposite party number 2 ta election the sub collector to com likhi diyantu so that you dita page ku change kariya pai you file karantu interim application for amendment. Once that is allowed, these 2 pages should be changed, matter would be regularized, right? The Land Council for the petitioner seeks permission to carry out certain amendments in the cost title by filing an interim application. You will file tomorrow. So we are granting you by a submit that you will do it the same. Interim application will be filed by 10th of March 2025.
Election hybrid elections here and Pancus and competent authority.
Cost title bhul So put up this matter on 13th of March 2025 along with the IU if any file. Yes. Mr. Adding agents note for the
till then, my lord, they are starting construction over
filed appropriate application is yes.
Item 16.
My lord, on behalf of Mr. P.K.Sahoo, he has some personal difficulty, my lord, so he could not attend today. Kindly taken up.
You want adjournment?
Yes. Next week.
Land Council for the. What is your good name?
Smrutidhar Patti.
Huh?
S. Patti, Smrutidhar Patti, my lord.
You have no power in this case?
No, my lord.
Asha Swansu submits on behalf of Mr. Prashant Kumar Satpathy for adjournment. List this matter on 13th of March 2025. Item number 1
As over item number 1,
My lord, I beg your pardon. I am not thorough with the case. Kindly be given time till next week.
You hand over the file to the state government. Your name is Mr. A. Patnaik.
Yes, my lord.
Full name Tadun. So on so. One counsel appearing for the petitioner 6 for an adjournment. This matters. You want it next week or
Next week, my lord.
next week? Place this matter on 13th of March 2025 with WPC number 21546 of 2023. Keep in mind that whenever you also go to any court for seeking adjournment on behalf of your senior, you just give a glance to the brief. It will be better for you. No? Yes.
Thank you, my lord.
item 17,
Master my lord, I had mentioned because of the fact that it's a land acquisition matter. The petitioner challenged the 11-1 notification with respect to acquisition of his land, alleging that the alignment of the canal was cutting across a portion of his land. He was entitled to compensation. Now, my lords, depending on his representation, we have changed that alignment, and I have filed an additional affidavit to this effect. Since the alignment has been changed, the canal is no longer touching his land or any portion of his land.
Where is that affidavit?
My lord, that affidavit, my lord, 17-125 affidavit.
17-1
at page 62.
25. Have you served a copy on Mr.
Yes, I have received.
What is your instruction on this?
Paragraph 4. As per the instruction affidavit filed, the writ application may be disqualified.
The
only thing is, there is a notification under Annex 4. As per this affidavit,
they will not touch your.
Yes,
that's. Let's come. This writ petition has been filed by the petitioner Sushant Kumar Jana with a prayer to pass the notification dated 6/4/2022 under Annexure 4 in respect of the land and building of the petitioner. So, the
plans to page 27, the land particulars has been given. That is Khata number 364 by 777 with 2 plots. At page 27 of the plot.
plot number mention कर देले better हो.
Khata number, plot number, 13 number serial.
Next
13 number serial.
13 number serial.
It is easier, my lords, because the next page mentions these details. 28.
Acha.
Notification achi page 27 ne. Plot khata number 364.
The plot of the land of the petitioner appertains to page number 27 rachi serial number 13, right? Dita plot lekha heichi 1824 an additional affidavit has been filed on behalf of opposite party number 215, wherein in paragraph number 4 it is stated as follows. Quote the entire paragraph. Paragraph number 4. The land counsel for the petitioner submits that since the alignment of the canal has been changed and as per the additional affidavit, the aforesaid 2 plots of the land are not to be utilized for the purpose of the construction of the canal. he may be permitted to withdraw the writ petition. Accordingly, the writ petition
Disposed of.
the writ petition may be disposed of. Accordingly, in view of the swansea, the writ petition stands disposed of. Yes.
One land interim order.
The interim order stands back again.
And the land is released from the land acquisition. Otherwise, if this notification will remain, then the affidavit will not do. If this
ଆପଣଙ୍କର ସେ ଏଇ ଏଣ୍ଟାୟାର ସେ ଯାହା ଲେଖିଛନ୍ତି ଲେଖିଛନ୍ତି ଆପଣଙ୍କର ପୁରା କ୍ଲିୟରଲି ଲେଖିଛନ୍ତି ଦି କେନାଲ ରୁଟ୍ ୱିଲ୍ ବି ଡାଇଭର୍ଟେଡ୍ ଆଣ୍ଡ ୱିଲ୍ ନଟ୍ ଏଗୁଡା ସବୁ ରହିବ ସେ ଅର୍ଡରରେ ୱିଲ୍ ନଟ୍ ପାସ୍ ଥ୍ରୁ ଦି ପ୍ଲଟ ନମ୍ବର ଏଇ ଦିଟା ହଉଛି ଆପଣଙ୍କର ପ୍ଲଟ ଅଣ୍ଡର ଖାତା ନମ୍ବର ଅଣ୍ଡର ସ୍ୱାନ୍ସୋ ଏଟା ରହିଲା ଆଉ ଆପଣ କଣ ଚାହୁଁଛନ୍ତି
notification release ନହେଲେ suppose tomorrow I will sell a 1 decimal of land. If this notification will remain, the sub-register will not endorse the sale deed because this is the acquired land. This acquisition is not, they are not withdrawing this acquisition. They are saying my land is not required. Therefore, my land is released from this acquisition.
So,
I'll take instructions because this notification has multiple landowners' land.
से particular land
particular land restricted.
This particular land affidavit ଦେଇଛନ୍ତି. My land is released from the acquisition.
It presupposes that your
yes,
that
it presupposes
that
if it will be clarified, it will be better. If it will not, if my land friend has some objection,
No, I have no objection. It's just that
notification is in ଯୋଉଟା additional affidavit ଦେଲେ तो
You have to take a follow-up action.
follow-up action କରିଦେଇକି
Clarifying it.
In view of such affidavit, the follow-up action has to be taken by ये ना वो से जो by
the special land acquisition officer has to
fresh notification अपन नहीं आसीबे जे एई land गुडा को release कर दिया गला that is to be done by whom? Let us
special OP number 5.
OP number
Special land acquisition.
The follow-up action shall be in view of the additional affidavit file. The follow-up action has to be taken by the special land acquisition officer Anandapur of opposite party number 5 in releasing the 2 plots of the petitioner from the
land acquisition
from the land acquisition.
Item 18.
Yes.
My lord, I am appearing for the petitioner. The requisites have already been filed and copies already been served in the late on dated 21st February 2025. Opposite party number 5.
The requisites file requisites for response on notice. अपन डेवी रे फाइल करचंती डेवी पाइन नोटिस कुड नॉट बी इशूड रिसिप्ट शोइंग अपन एटा फाइल कर दी रिसिप्ट शोइंग एक्स्ट्रा कॉपी ऑफ द रिट पिटिशन ऑन द लैंड एंड काउंसिल फॉर द फाइन
Yes, madam.
रिसिप्ट एठी देखेले कोन अपन गोटे से रिसिप्ट को अनेक्स करी देखलेनी से नोटिंग दउचंती ये रे लेखन द you have already annexed that receipt.
Yes, madam.
All right. The Land and Counsel for the petitioner. अच्छा इट ऑफ लिख दिया ऑफिस नोट लिख दिया The office has pointed out that the requisites for issuance of notice to opposite party number 5 to 8 by speed port with proof of delivery could not be notice could not be issued since the requisites for issuance of notice to opposite party number 5 to 8 by speed post with proof of delivery was filed late, that is on 21/2/2025. Let the requisites be accepted and the office to proceed. Second, it has been further stated, reported that the receipt regarding service of extra copy of the writ petition and the Land Council for the state has not been filed. The Land Council for the state has filed, the petitioner has filed the document upon food file question. Have you got that document with you? That you have served the copy, you have received the copy?
Yes.
It must be, it's not in my file, but it says the receipt we would have received in an email. I'll get it.
ଆମର ଇଏ ପାଇଁ ଗୋଟେ ଜେରକ୍ସ କରିକିନି ଗୋଟେ ମେମୋ ସହିତ ଦେଇ ଦିଅନ୍ତୁ ହେଲା, so that ସେ ମେମୋଟା ନେଇ ଆସନ୍ତୁ ଯୋଉଟା ରିସିଭ୍ ଦେଇ front so with a memo which is taken on record. List this matter ଏଟାକୁ ରଖିଦିଅନ୍ତୁ 4 weeks ପରେ ଆଉ ଗୋଟେ ଡେଟ୍ ଦେଇଦିଅନ୍ତୁ. Yes.
Item 19.
Yes, item 19.
19 typographical error.
Date of the order in number 1 has been typed as so and so instead of. It is to be read as per them. It has been pointed out by the registry that the date of order number 1 has been inadvertently typed as 25/1/2025 instead of 25/2/2025. The same shall be read as 25/2/2025. This order be also uploaded. Yes.
Item 20.
Same. Number 1920.
Yes.
Interim valuation. Earlier you will see 2/9/2024. You will see
ସେଟା 9 ନମ୍ବର ଯୋଉଟା ପହରଦିନ ଥିଲା
9.
Supplementary list. Item number 9.
Pacha filed the IA seeking a release of his will on account of the death of his grandmother. His grandmother died since 10 years back. May I kindly see the report by the IA.
So the earlier report was confusing. That's why we asked
Yes.
you.
Now he's given a
I've
clear
obtained a
report.
better report to them. Now, actually, the person who has died is the.
Yeah, just a minute. This is the report, correct report.
This is the report by the
Latest.
IAC, present report. Yes.
ସେ ଇଂଲିଶ ଭୁଲ ଭାଲ ଲେଖୁଛନ୍ତି ସେଥିପାଇଁ ବାଉଳା ହଉଛି. Let us see.
May I? May I
Please, please read it out.
Ma'am. With reference to the message that sponsor received from the office of the sponsor, I have made an inquiry in the locality about the aforesaid case and ascertained that the grandmother of Kanta Muduli, appellant number 2, namely Gauri Muduli, has already expired since 10 years. Kanta Muduli, appellant number 2's mother, have two sisters, namely one Kolavati Muduli and Milli Muduli. Milli Muduli is the auntie of the Kanta Muduli, married to one Basanta Muduli of the same village. On 28/2/2025, the mother-in-law of the Milli Muduli, namely Bamani Muduli, has expired.
नहीं यार ना कौन की
Kanta Muduli. You may kindly see the IA for a minute.
ठीक है रूम କଣ୍ଠମୁଦୁଲି
The ମାଉସୀର ଶାଶୁ expire କରିଯାଇଛନ୍ତି ଏବେ.
କଣ୍ଠମୁଦୁଲି
ସେ ଡେଟ୍ ଟା ଟିକେ ଭୁଲ ଲେଖିଛନ୍ତି. It should be 28/1.
It should be 27/1, Your Lordship. For that reason, I've given a report of the jail.
Very good, very good.
So କଣ୍ଠମୁଦୁଲି mother have two sisters. So and so. ତାହେଲେ ଯୋଉ ମରିଗଲା କିଏ ମଲା ତାର?
The ମାଉସୀର ଶାଶୁ. So kindly see page paragraph 4 of the IA.
Yes,
the name matches.
ମାଉସୀର ଶାଶୁ.
ଏବେ ଆଜ୍ଞା 27 ବାପା ମାଙ୍କ ଡେଥ୍ କହିକି ଯାଇଥିଲେ.
କୌଣସି ତାଙ୍କ ରିଲେଟିଭ ସହିତ କିଛି ଯୋଗାଯୋଗ ନାହିଁ ଜେଲରୁ ସେ ଯାହା ମାନେ
ଯାଇକି ଆପଣ କହିଲା ବେଲରେ ଛାଡ
ମାନେ ଗ୍ରାଣ୍ଡମଦର ମରିଛି ବୋଲି
ଆସି ମେନସନ କଲେ ଆପଣ ଆମେ ଭାବିଲୁ ଏବଂ ତାପରେ ମଧ୍ୟ ଆମେ ଆପଣଙ୍କୁ ପଚାରିଲୁ ଆପଣ କହିଲେ ଯେ ତାଙ୍କ ମାନେ ବୁଢୀମା ମାନେ ମାନେ ପ୍ୟାଟର୍ନାଲ ସାଇଡ
ଦ୍ୟାଟ ଇନଷ୍ଟ୍ରକ୍ସନ ଇଜ ଦ୍ୟାଟ ଆଜି ବି ସକାଳେ ସେ ଜେଲରୁ ଫୋନ କରିଛନ୍ତି ଯେ
ଆମେ ସେ ଟେଲିଫୋନିକ ଇନଷ୍ଟ୍ରକ୍ସନ ଅନୁସାରେ we have to proceed ନା କଣ ଏଟା ତ written that is why we called for.
It is supported by Sarpanch's information.
Number 66677 of 2025.
ଆପଣ ଲୋକ 27/1 ରୁ 7/2 ଯାଏ ଯାଇଥିଲା ପେରୋଲ ବୁଝିଲେ
On account
ସେ ଯାହା ବି ହଉ 27/1 ରୁ 7/2 ସେ ଯାଇଥିଲା ପେରୋଲ.
The Land Council for the state has produced the written instruction received from IAC Document Police Station.
We had asked for instruction.
Which indicates that the averments taken in the interim application that the grandmother of the petitioner expired on 28/2/2025 is not correct. The grandmother of the petitioner, appellant number 2, has expired since 10 years. The instruction reads as follows, quote in the Quran. The Land Council for the further state has further produced the instruction received from the Senior Superintendent Circle Jail, Koraput, which indicate that the petitioner was released on special leave for a period of 12 days with effect from 27/1/2025 to 7/2/2025 and has surrendered to the jail custody in time, that is on 8/2/2025 after availing the special leave. The documents are taken on the call. In view of the documents received, we are not inclined to release the petitioner on interim bail, stands rejected.
Item 1.
The petitioner was released on 19th December. Pursuant to the order of this Honorable Court on 1st of October 2024,
The appellant was released on 19th of December on interim bail.
19th of December.
Yes, sir.
So that period has not expired.
No, Your Lordship.
You have been released on interim bail for 3 months.
Yes, Your Lordship.
Right. What is your good name?
Anvesha Mishra. Your Lordship, one more submission. Lordship, you have filed a interim application for extension, Your Lordship.
No, that has not come on
No,
record.
Your Lordship, that has not come. If I may pray, Your Lordship, if
All
we
right.
come with the...
One so submits that though the petitioner, though the appellant was directed to be released on interim bail for a period of 3 months, as per the order dated 1/10/2024, passed in IN number 2107 of 2024, but the petitioner, after furnishing the bail bond, was released from jail on 19/12/2024, and therefore the interim bail period has not yet expired. Stop. She further submits that the petitioner has that the appellant has filed an interim application for extension of the interim bail period, which has been numbered as IN number.
Lordship, it has not been numbered.
आज ही file करें?
Yes, sir.
Today.
It is
अच्छा.
filed.
Put up this matter next week with the interim application for
Okay.
extension. Yes.
Item number 2. Item number 2 lost. So I have to stop the deposition copy to my learned friend or told me. Next week.
Mr. Dhol and counsel appearing for the appellant submits that during
Custody since when?
Since, Your Lordship, 5/6/2014, Your Lordship.
Are the land counsel for the, what is your name?
Adishakti Priya, Lordship.
Adishakti Priya, land counsel appearing for the petitioner
On behalf of
On behalf of the person.
Devashananda and land counsel for the state. The land counsel for the petitioner submits that the petitioner is in judicial custody. Petitioner, who is the husband of the deceased, is in judicial custody since 5/6/2014. And there are no eyewitnesses to the occurrence. Case is based on circumstantial evidence, and it's a case of burn injury. And not a single witness has stated that the petitioner was present in the house when the occurrence took place. Further submits that the petitioner was a rickshaw puller, and there are poor chances of success in the appeal, and balance of convenience is in his favor. Therefore, the bail application may be favorably considered. Land counsel for the state oppose the prayer for bail. Place the evidence of VW 1 and 2. Oh, doctor ki bail
10 years.
VW claim was stated that the cause of death was on account of burn injuries, and the deceased died of shock and suffocation. Considering the submission made by the land counsel for the respective parties, nature of evidence available on record, and the manner in which the death has taken place, while not inclining to release the petitioner on bail on merit, but taking into account the period of detention in judicial custody and the fact that there is no chance of early hearing of the appeal in the near future, as paperwork has not been prepared, you are inclined to release the petitioner on interim bail for a period of 3 months. Yes.
Grateful, Your Lordship.
Item 4.
paper books be prepared.
Paper books be prepared in the meantime. Date copy the opinion as for it. Usual order जोड़ा दे surrender certificate file करो. Yes.
3 मास छाड़ के 2 सप्ताह छाड़ दिया ना बाहर
You have to treat this matter after obviously summer vacation. Yes.
May I please?
Mr. Mishra.
My lord, the appellant has been convicted under section 302 and sentenced to undergo.
You have received the deposition copy in your pen drive. Okay, proof is. Yes.
Convicted under.
Is it your first application?
Yes, sir. First application.
What is the date of custody?
Custody from 29/2013.
Good year now.
Okay.
We just hold on. What is the offense here?
Or 302 and the allegation.
Come to the paragraph number 2 of the document.
My lord. PW1 is the eyewitness to the occurrence.
Please come to the paragraph number 2. Let us see then.
The prosecution case is that on 18/9/2013 at 9:30 p.m., the informant Srimati Jasoda Mohanto, she is the mother of the appellant, lodged a written report before the IAC Kaliapani PS to the effect that in the evening at about 7:30 p.m., while she was cooking and her husband Madhav Mohanto was taking rest. Madhav Mohanto is the deceased one.
What charge?
Was taking rest on a cot at home. Her son Ganeshwar alias Raja Mohan, the present appellant.
So you killed your father, that is alleged.
Yes, it is a case of patricide.
Patricide.
Her son Ganeshwar Mohan alias Raja Mohan came into the house and assaulted her husband. The
the accused picked up a crowbar, pulled him out to the courtyard and severely assaulted him. Whereas daughter-in-law, Jana Mahanta, was instigating to kill the old man, the wife of the appellant. At that time, her nephew...
You were charge sheeted?
No.
All right.
At that time, her nephew Kulomani Mahanta rushed to the place and restrained the accused and snatched away the crowbar from his hands. But her husband died at the very spot. Hearing of the incident, SSG group members and other villagers came to the place and tied the accused with his wife. Prior to the incident, the wife of the accused had quarreled with the deceased and threatened of dire consequences after return of her husband. On this report, Kaliapani police registered PS case number 16 of 2000.
What are the injuries sustained? Who is the doctor?
Doctor is PW14, madam.
And sole eyewitness is PW1.
PW1 is the mother.
And PW4?
PW4. PW4 is he is not a. It cannot be said that he is an eyewitness to the assault. He came after the assault was made. He has stated in his evidence.
I rushed to the spot followed by.
He has stated that after my arrival, there was no assault.
Is there any property dispute? Why you killed your father?
My lord, quarrel with regard to sale of paddy. That is there in the evidence. PW1 has stated that in our evidence that at para 3, Lord Sigma kindly see in our evidence, one blow to the head.
Only one blow or all over the body?
One blow to the head. PW1 has stated.
Only one blow or only one blow to the head?
There is a contradiction, my lord. PW1 stated that only one blow to the head, but the PM report suggests that the cause of death is internal hemorrhage and hemorrhagic shock, and death is due to respiratory failure.
Because the injury is on the chest.
Third, fourth, fifth, 3 of the right side chest.
Again.
That has been fractured, and whole chest cavity is full of blood, and
the accused quarreled with my husband, and when I protested, he pushed me and I fell down. The accused picked up a crowbar and assaulted my husband near the ear and other parts of the body, causing swelling injuries.
Para 3, Lord Sigma kindly see. PW1. Para 3.
ଆପଣ ମାଙ୍କର ବୟସ ବର୍ତ୍ତମାନ କେତେ ହବ? 70 ବର୍ଷ ହବନି, କାରଣ 60 ବର୍ଷରେ ଦେଇଥିଲେ, ଡିପୋଜିସନ କରିଥିଲେ 2014, ବର୍ତ୍ତମାନ 2024 ହେଲାଣି 25, 70 ବର୍ଷ ଗଲେ ତ ଫାଷ୍ଟ ମା ଟାକୁ ମାରିଦେବେ, ମାରିବେନି କଣ? ମା ସାକ୍ଷୀ ଯୋଉ ଆପଣଙ୍କୁ କନଭିକ୍ସନ ହେଇଛି ନା, ଏ ବୁଢୀ ଲୋକ ଆରାମରେ ଅଛି ବର୍ତ୍ତମାନ 10 ବର୍ଷ ହେଲାଣି, 9 ବର୍ଷ ହେଲାଣି।
ମୋ ସ୍ତ୍ରୀ ବି ରହୁଛି ନା
ବାପାକୁ ଛାଡିଲେନି ଆଉ ମା କଣ ଛାଡିବେ?
Yes, paragraph 3. She says head re one blow.
One blow.
That doesn't mean other part of the body stop blown. That is why I was asking you then.
What is the status of the PW1?
But PW4 saying
no. ये अच्छी ना गलानी, ये जो ଯଶୋଦା ମହନ୍ତ ତା ମା ଯିଏ, ଆଉ ତାଙ୍କ ସ୍ତ୍ରୀ ବର୍ତ୍ତମାନ କୋଉଠି ରହୁଛନ୍ତି?
ସ୍ତ୍ରୀ ସେ ତ ଇଏ ଗଛ
ଆମେ ଇନ୍ସପେକ୍ଟର ବୁଢୀ ମାରିଦେବ ନହେଲେ। Take instructions.
Direct evidence.
Let it come after, and you take instruction in this matter. IA number so and so.
Paperwork ready.
Are you ready for a hearing?
Keep it for hearing.
All right, IA number so and so. All right, this is an application for bail in view of the evidence of PW1, the eyewitness, also the evidence of the doctor, PW14. We are not inclined to release the petitioner on bail. However, since the petitioner is in judicial custody for since 29/2016, and paper book has already been prepared, the matter be added to the hearing list in the quick convincing from 21st of April 2025. Yes. The relation of entire
Item 5.
Yes.
So given the report, are there
I will see the
behavior of the accused group?
He had been granted interim bail earlier, so regarding his conduct, a report had been.
You have already surrendered.
see.
The land counsel for the state has produced the report of the IAC, Bada Police Station, dated 13/1/2025, which is taken on record. So people should be.
Date what के बोल रखे हैं?
नहीं तो date है
Okay.
normal course है actually hearing है तो फिर matter will be listed in the normal due course करते हैं. Yes.
Item 6.
Report from
He is Onal sir.
letter of the
Kali di.
criminal person for release of his bail and it was provided by the state legal affairs. It was directed for preparation for
अरे ये इंडेक्स किए तो अच्छी तो 5/3/2025 ना करके 18 कर दीजिए. Order dated. 7 काली थिला कोना दी 5/3/2018.
date of custody 3/5/2013.
What is his age?
Age 70. 72.
अब ये offense from 302.
Yes, sir.
काली हम
RI for
डिसीजन
life.
पे देखे ना चले जोना 70 years रे बेल छाड़ देथिले
ना,
सी 45.
RI for life.
So,
एक राउंड
here how many number deceased is one or more?
No one man. One and
Lakshman Naik.
weapon of offense is really
Paragraph number 2 question.
judgment man. Yes, ma'am. The sum and substance of the prosecution case is that one Navajishwar Naik, son of late Lakshman Naik of village Pikol Bahal, presented a written report before the IAS Chandipada PS on 2/5/2013 alleging to the effect that he received information regarding lying of the dead body of his father in the house of one Pramod Sethi of village Rasi Malia. Inside the orchard coming to the village Nasimalia, he collected information that on the same day, around 12:30 am, PM, his father came running while he was inside the orchard of the Pramod Sethi and sat on the veranda of the house inside the orchard, asking the wife of the Pramod Sethi for water.
You have another case under 302.
This one.
No? And during bail, in that case, you have committed this offense.
No, that is not reflected, but as it assumed that there was a.
No, you have been convicted. We want to know
Yes,
that what happened in the appeal in that case. Mr. Have you gone to the paragraph number 3 of the judgment? हाँ, the conviction is तो जेल ले थिबो ना तारो डाटा थिबो जदी अपील प्रिफर करथिबो से अपील रो नंबर थिबो अपील रो रिजल्ट जदी ही जाइथिबो आ भितरे कारण 97 न केबे जानू कन्विक्शन हला तो सेटा को असर्टेन करंतु
ना उटे प्रॉब्लम वेदर से कमिटी रो ये रे डबल जारो प्रीवियस कन्विक्शन थिबो ताकू छाडी होगी नहीं
Better सेंटी किसी
अलता ता बॉयस देखी कि वी वर
only is they are taking.
नहीं एज ठीक अछि जे फॉर्मेट भी देई जंदी किन तादेर किछि स्पेसिफिक ये रखि ना खाली कैटेगरी दीटा रहुचंदी गोटे होची पर्सन एजेड 70 इयर्स रे कॉलम नंबर 12 रे अछि आ गोटे रखा जाउची जे प्रिजनर्स विथ टर्मिनल इलनेस हां ତେଣୁ ଏଇ ଦିଟା କ୍ୟାଟାଗୋରୀରେ ଯଦି ହବ ତାହେଲେ କନସିଡର କରାଯିବ ବୋଲି ହେଇଛି but again if we find that it is a second time he has committed this one in first 302 he has been found guilty, let us say while during course of being released on bail he has committed this offense, then that is to be on the age ground. If it is not a single case, then the consideration would be otherwise.
Page 54 ରେ ବି ସେଟା କିଛି reflect ହେଇନାହିଁ the second case involvement in second case.
ସେ ଫର୍ମ ରେ କହୁଛନ୍ତି
ନା ନା ସେ ଆଉ ଗୋଟେ କଣ
ଯୋଉଟା ରିପୋର୍ଟ ହେଇଛି to the superintendent of jail on board form 60 ଯୋଉଟା ଦେଇଛନ୍ତି ସେଥିରେ ମଧ୍ୟ second case
ବାହାର କରି ଦେଇଥିଲ ଯୋଉ ଜେରକ୍ସ ଟା
ହଁ ହଁ ସେଟା ଦେଇଛନ୍ତି ରଖିଛନ୍ତି କୋର୍ଟରେ
ତମେ ରଖିଲେ କଣ ତମେ ପଢିବ ନା କଣ? No, why have you not given me? I mean, you should have given me. घरे पढ़िए ना कोई give it to me. घरे तो ये पर ठीक होना. You take instruction on that, huh?
Is it there in the judgment? Judgment ରେ ଲେଖା ହେଇଛି otherwise while sentencing or anything?
ଖାଲି involvement
Only that
earlier conviction
paragraph 3
ନା paragraph 3 ତ ଅଛି
ଆଉ कुछ नहीं
sentencing ବେଳେ that is
ना
important.
उसका discussion
Yes. Page 9 it is there.
Page 9.
The present convict faced trial as an accused relating to Chendipada न देखिए नाटा काहे सेमती कहि दउछन मु बुझ पानी Chendipada PS case number so and so he was convicted. There is no scope for any liberal view. कौन कहले किछि नाही देखिकी कहबे ना सेमती कहले आपन को ऊपर हमें विश्वास केंती करिया पढिथिले आ एटा देखि नथिले
मोर
मारिचंती मारथेकी रखिथांतो पाखरे.
This is the prisoner's petition. This is the prisoner's petition of the appellant filed for his release under the special campaign by NALSA. Stop. In the form it has been mentioned that the petitioner is aged about 70 years. While going through the judgment, it appears that the petitioner earlier faced trial in Chendipada PS case number 46 dated 9/7/1997 under section 302/34 of the Indian Penal Code, and he was convicted.
Paragraph 14
Stop. Let the learned counsel for the state obtain instruction as to whether any appeal has been preferred against the said judgment and order of conviction, and if so, what is the status of the appeal? Put up this matter on केबे रखिवा कोनते the jail superintendent to yes
the paper will be there, let it be handed over to me. And the LCR
put up this matter on also. Let a copy of the paper book be handed over.
And the LCR will be supplied
to the Land Counsel, Mr. Rayaguri. Trial court recorder कौन दरकार अपन को?
This appeal was engaged by this honorable. I was engaged by this honorable court. I have
paper book how कौन दरकार कौन No, you go through the paper book. If you require something else, you can say and we can supply to you. Because there may be so many things, case diary thibo, अन्यान्य जिनस thibo, so बहु जिनस thibo. Upon कोनटा दरकार.
What happened? The seizure as well as the confessional statement, they have not been proved by the.
Upon if you say specifically that these are the documents which are necessary, that kaରଣ ବାକି ସବୁ ଜିନିଷ ୟା ଦେହରେ ଆସୁଛି ଆପଣ entire order sheet of the trial court that is available here. While you argue the matter through Wacom, you can get this document. So if apart from the after going through the paperwork, if you need some other documents, we can pass appropriate order so that hello. Yes. So let it come on 24 of March 2025. You obtain that status of that first case. That is the first case for us in the status of the criminal case in which he was convicted. Yes.
Item 7.
The item 7, the murder of 4 persons.
Murder of 4 persons?
Yes. 736. CRL 36.
The CRL 36.
CRL 36.
There is a case under section 376 2I.
The wrong file has been found. CRL 36.
The Land Counsel for the state seeks for an adjournment till next week. Put up this matter. 13 March 2025.
There was a specific instruction.
Number 5 ଆଣିଥିବେ ମାନେ ଆଣନ୍ତୁ ଦେଖି କାଳେ ଆସିଥିବ ପୁଣି
Item 8.
Is convicted on page 2 IPC for life. But the accused was custody since 1916. 20 witnesses have been examined. And
you have got the deposition copies with you?
Yes, ma'am.
So, just a minute. Is it your first application?
Yes, ma'am.
Okay. What is the date of custody?
That is 1916. Incident
19/6/2016. 302 case.
Yes, sir.
Okay. Is direct evidence or circumstantial?
No, circumstantial.
Circumstantial evidence. Name of the deceased?
Name of the deceased Sanju Balmuch.
Sanju.
Yes. Sanju Balmuch.
Balmuchu. Date of occurrence?
That is the 1916.
19/6/2016. So, what are the circumstances where it has been discussed by the learned trial court that these are the circumstances?
That is page number.
Acha, paragraph number 9, page 14.
Yes. 9.
How the deceased was related to you?
Wife.
Acha. So, one is there are frequent quarrel after consumption of liquor. Next one, try to bury the dead body in concealing in order to screen the evidence. So, where the dead body was found?
That is in the house.
Inside the house.
It's called PW3 there, saying he has fever. He reached and found it. Injuries all over the body.
So, both were staged.
So, and the deceased staying together.
Yes.
and your wife has made homicidal death.
Yes.
The doctor has noticed
Yes.
number of injuries.
Yes.
The doctor is PW?
Doctor is PW 11.
PW 11 doctor. He has noted 5 lacerated wounds, out of which the injury number 1 is on the head. Right?
Yes.
All right. So cause of death has also been opined, shock and hemorrhage caused by head injury and other multiple injuries. So what is your statement in the 313? How your wife died, homicidal death while staying with you?
They fell down from the roof.
Huh?
Fell down. That is a head injury. That is
ଘର ଭିତରେ ପୁରା ପଡିଥିଲା
yes.
ଘର ଭିତରେ roof କଣ ପଡିଲା
ସେ ଯୋଉ ମୁଣ୍ଡ ମାଡ ହେଇକି ସେ
ଘର ଭିତରେ ପରା ଆପଣ ଘର ଭିତରେ ଥିଲା ତ
ଘର ଭିତରେ
ଆଉ roof ରୁ ପଡିଲେ ସେ ବାହାରେ ପଡିଥାନ୍ତା
ନାଇଁ ସେ ଘର ଭିତରେ ତାର ଯୋଉ statement is that it's a ଘର only head injury that is fell down from the roof.
ମୁଁ କହିଲି ପଡିଗଲା ମୁଁ ତ ଘରକୁ ଆଣିଲି ମୋ ସଡକୁ କହିଲି ବରି କରିଦବା ସେ ପୋଲିସ
ଆପଣଙ୍କର ୱାଇଫ ଯଦି ଛାତରୁ ପଡିଗଲା ଖଣ୍ଡିଆ ଖାବରା ହେଲା ହେଡ ରେ ଇଞ୍ଜୁରି ହେଲା ତାକୁ ନେଇକି ଡାକ୍ତରଖାନା ଯାଇଥାନ୍ତେ ନା ଡାକି ତାକୁ ପୋତି ଦେବା ପାଇଁ ଚେଷ୍ଟା କରୁଥିଲେ
ସଡକୁ ନେଇ ତାଙ୍କର ଗାଁରେ ଗାଛ ଖୋଳି ପୋତୁଥିଲେ ଭିଲେଜର ସପୋଜ କଲେ ଭିଲେଜର ସାଇଲେ ଇଏ କହିଲା ମୁଁ ଯାଉଛି ଗାଡି ଡାକିବି ବୋଲି
ଗାୟବ ହେଇଗଲା ସେ
that is the one of the circumstances to injury.
ତାକୁ କହୁଛନ୍ତି ଯେ ସେ ମଦ ପିଇକି ମାରୁଥାଏ ମଦ ପିଇକି ବାଡଉଥାଏ ସ୍ତ୍ରୀକୁ ସେଇଟା ବି ଅଛି
Very frequent work. The co-laborers are also
examined.
You see, you have not put any question also to the postmortem doctor, the doctor who conducted postmortem, that such injuries can be possible if somebody falls from the roof. Number 1. Number 2, if somebody falls from the roof and sustain the injury, there would be a spot where there would be bleeding.
Yes.
Right? So naturally, ବାହାରେ ଅଗଣାରେ ପଡିଥାନ୍ତା ଛାତ ଉପରୁ ତ ସେଇ ଜାଗାଟା ତ ଆଗେ ରକ୍ତ ହେଇଥାନ୍ତା ତାକୁ ଯଦି ଘର ଭିତରୁ ଆଣିଥାନ୍ତେ ସେଠୁ ତ ଟ୍ରେଲିଂ ମାର୍କ ଥାନ୍ତା ବ୍ଲଡ ଟ୍ରେଲିଂ ମାର୍କ ଥାନ୍ତା ଆଉ ଆପଣ ତ ସେଗୁଡାକ କିଛି ନାହିଁ ଛାତ ଉପରୁ କଣ ପଡିଗଲେ
para 6 of the
ପଡିଗଲେ ଗୋଡରେ ଇଞ୍ଜୁରି ପାଛିଟା ଇଞ୍ଜୁରି ଭିତରେ
that the cross examination period 11 that is the para 12 doctor medical action that is the I did not para 12 the cross examination I did not find any stab injury over the body the deceased though the requisition reveals about the stab injury this requisition of the IO does not specify the name of the weapon said to have been used for the commission of offense. I have not received any weapon of the offense although the dead body along with the dead body weapon of the offense was received on a subsequent day that is on 16/11/16. I have not specifically informed the IO that as against the requisition I did not find any stab injury over the dead body.
ଡାକ୍ତର କୁ ଯାଇଥିଲା query ଯେ whether it is possible by the କଟୁରୀ and the broken piece of the cycle pump ମାନେ cycle pump ରେ ମାରି ମାରି ଭାଙ୍ଗି ଦେଲେ
No, so that is not also
not correct.
No, pedal 15 that is statement 15. Internal page 94 para formula. I conducted a preliminary examination of the exhibits which were found having blood stain except exhibit A1, B1. I packed, labeled, sealed and I handed over the exhibits to the IO at the spot which is same under Annexure 6 under exhibit 6 in presence of the independent witnesses. Exhibit 6/2 is my signature on exhibit 6 I advise the IO to send this exhibit. Then para 7, para 4 is the cross exemption. That is the
11. Head root injury, left leg, right arm with detaching. Laterally detaching. That's represented. Total 5 external injury. Head injury, who is responsible for death. So how do you discharge your burden under section 106 of the Evidence Act? ଆପଣଙ୍କର ଯଦି ପ୍ଲିଟା ଯୋଉ ପଡିଗଲା ଯଦି ଆକ୍ସେପ୍ଟେବୁଲ ନ ହୁଏ ଯୋଉ କଣ ଛାତ ଉପରୁ ପଡିଗଲା ତେଣୁ ବାକି ରହିଲା ଆପଣ ଆଉ ଆପଣଙ୍କର ୱାଇଫ ଏକାଠି ରହୁଥିଲେ ଗୋଟେ ଘରେ ଆପଣଙ୍କର ୱାଇଫ ଡେଥ୍ ହେଲା ହୋମିସାଇଡାଲ ଡେଥ୍ ତାଙ୍କୁ ନମ୍ବର ଅଫ ଲ୍ୟାସରେଟେଡ ୱୁଣ୍ଡସ୍ ରହିଛି ତାଙ୍କ ବଡିରେ ତେଣୁ ସେଗୁଡାକ କୋଉଠୁ ଆସିଲା କିଏ କଲା ତାକୁ
weapons has been used, that is para 4 of the Title 15. Weapons has been used so that intention of death is not there. There's para 4 of the Title 15 clear said that loss found where in dying state, no video recording of the spot was undertaken, no fingerprint was detected in the broken pieces of this cycle pump and cutlery. I did not prepare any spot map. My
para 15 mechanical glass judgment.
କଣ ଅଛି
PW2, the IO in this case stated that while the police custody
15 para 15 କହୁଛନ୍ତି ତ
running page 20,
running page
23.
Yes.
PW20, the IO of this case has stated that while in police custody, the accused confessed is guilty and also stated that he had concealed his wearing apparels in his house, which he had used at the time of occurrence, and led PW20 to the spot and gave recovery of the said wearing apparels, and accordingly, his statement was recorded in 27 Evidence Act. Exhibit 12 and also seizure list was prepared on Exhibit 3/2 in the respect of the wearing apparels. Exhibit 12 is the statement of the accused in the police custody, and he confessed his guilty and stated that he not only assaulted deceased by means of iron pump and cutlery, but also dashed his head on the wall. So the said fact is inadmissible in evidence as per section evidence, but his disclosure regarding his wearing apparels is admissible. Well, it is true that the witness to the seizure and the recording of the statement of the accused 27 Evidence Act is not supported by the witness, namely Ashok Parida, 7, although they admitted their signature in Exhibit 3/2, but did not support the prosecution case. Once the Exhibit 3/2 with the signature is admitted, subsequently incriminating even in case of incriminating questions put to him that about the death, but he did not discharge. That also the additional link date of chain of circumstances. Both are residing in one house. That how they recording. तापर से dead body टा निजे सड़ू डाकी नहीं की गले.
There was an attempt.
Instead of saying that would have been reported at a hospital for treatment. ଯଦି ଛାତରୁ ପଡିଲା ବୋଲି କହୁଛନ୍ତି ବି ତାଙ୍କ ମୁଣ୍ଡର
should have taken to the hospital.
ଆଉ ସେ ଯୋଉ ପୁଣି ସଡୁ ଯେତେବେଳେ କହିଲା ଡାକିଲେ ତାକୁ ଧମକେଇଲେ ଷ୍ଟେଟମେଣ୍ଟ
ଧମକେଇଲା ତାପରେ ତ ଦୌଡ଼ିକି ପଳେଇଲା
ଧମକେଇଲା କୋଉଠି ତାକୁ ଯେତେବେଳେ ନବା ପାଇଁ ସପୋଜ କଲେ କହିଲେ ମୁଁ ଅଟୋ ଡାକୁଛି ବୋଲି
he has been acquitted of that charge under section 201, found guilty under 30.
କରିପାରିଲା
It would have been attempt also, but that has not been. He has been.
So what has been stated there?
Recently, election got a line like this. Prosecution could not bring home the charge under just got a line. That's all. There was actually an attempt to cause disappearance of evidence.
Right. digging the well.
The appropriate charge would have been 201 by 511. But by the way, the charge has been framed under.
Acha, there is some mark of violence in his house, which has not been explained by him, though the same was put to him during his examination under section 330.
ପିଲାପିଲି କଣ ଅଛନ୍ତି? ପିଲାପିଲି ନାହାନ୍ତି ତ ଏଠି ଅଛନ୍ତି ଆରାମରେ ଖାଇ ପିଇକି ଆଉ କଣ ଅସୁବିଧା?
ଜେଲ ଯାଇଥିଲେ ଛୁଆ ପିଲାଙ୍କ କଥା ବୁଝିକି ଆସିଥାନ୍ତି, କିଏ ନାହାନ୍ତି?
ଷ୍ଟେଟମେଣ୍ଟରେ ସେତେବେଳେ 41 କହିଲା 2019ରେ ମାନେ 6 47 ଖଣ୍ଡେ ହବ 46.7. Are the land counsel for the petition, land counsel for the state, the land counsel for the petition. ए डेट ठीक अछि तो जो 1900 कहले ए फाइनल फॉर्म दवर करले ना कोन विजय पालच. No, it is wrong, Mr. Counsel. You are in proceedings 14/8/2016.
That is just forwarded.
এই সব জিনিস ଆପଣ ରେକର୍ଡଟା ଭେରିଫାଏ ନ କରି କେମିତି କହିଦିଅନ୍ତୁ? ଫାଇନାଲ ଫର୍ମରେ କ୍ଲିୟରଲି ଇଣ୍ଡିକେଟ କରୁଛି 13 ରେ ଆପଣ ଆରେଷ୍ଟ ହେଲେ 14/8 ରେ ଆପଣ ଫରୱାର୍ଡ ହେଲେ
14/8 ରେ ଫରୱାର୍ଡ.
ଆପଣ ଆମକୁ କେମିତି କହିଲେ 19/6/2016 ଦେଖନ୍ତୁ Proceedings 14/8/2016 and the case is based on circumstantial evidence and there are good chances of success in this case and there is no likelihood of the appeal being taken up for hearing in the near future as paperwork has not been prepared. Therefore, the bail application may be favorably considered. Land counsel for the state, on the other hand, opposed the prayer for bail and submitted that the deceased was the wife of the appellant. And though the appellant has taken a plea in the accused statement that the wife fell down from the roof of the house during labor work and she was brought to the house, but the doctor bracketed PW11 has noticed as many as 5 external injuries on different parts of the body, including the head, and opined that the injuries were antemortem in nature and the cause of death was due to shock and hemorrhage due to head injuries, so also the multiple injuries over the body. And the land counsel further submits that since the petitioner and the deceased were staying together, the petitioner has not offered any explanation as to how the deceased died of homicidal death. Some incriminating articles have been seized at the instance of the petitioner, basing on his statement recorded under section 27 of the Evidence Act. He should not be released on bail. Considering the submission made by the land counsel for the respective parties, even though there is no direct evidence in the case, but taking into account the circumstantial evidence on record, the postmortem report finding, while not inclining to release the petitioner on bail on merit, but taking into account his period of detention in judicial custody for more than 8 years, we are inclined to release him on interim bail for a period of 3 months. While on interim bail, the petitioners are not below Swansway. And basically, after 3 months, he will file the surrender certificate and conduct certificate on the nearest. Yes.
July first week ରେ ରଖିଦେବେ
Yeah.
Item 10.
Last petition, I was directed to file comprehensive debt check matter. So also, I have filed the same matter. The state also directed to produce the custody settlement.
You have got the custody certificate. What will be, how many years is in custody? 4 years. Yes. Offense under section
302
କାହାକୁ ମାରିଛନ୍ତି
Never of
never. Single.
No, number of co-accused are there.
No, murder, single murder, na?
Single murder. Yes.
Single murder.
Yes.
So, what is the prosecution case? Please come to paragraph number 2 of the judgment. Yeah.
The repeal from the extra that manner. On 10/6/2002 at about 1:30 p.m., the informant Pushpa Nanwar had been to the house of her husband's elder brother, namely Chala Nanwar.
Where are you reading? We have asked you to read the judgment, paragraph number 2. Yes. Are you reading from judgment?
Yes.
It's not that what you are reading.
Prosecution case in
prosecution case.
Yes.
Read it out. Yes.
Prosecution case in Norcel as follows. It is repealed from the FIR that on 10
as follows କୋଉଠି ଲେଖା ହେଇଯିବ?
ଆଚ୍ଛା ଆପଣ 4 ବର୍ଷ ହେଲା କଷ୍ଟଡିରେ ଅଛନ୍ତି ଏଫଆଇଆର ଟା ପରା 2002 ର ନା ମୁଁ ଭୁଲ ଫାଇଲ କରିଛି ଆପଣ କଣ ବାହାରେ ବୁଲୁଥିଲେ
Yes, I was
absconding.
I was arrested in 2014.
ମାନେ absconding for 15 years ନା କେତେ
15 years. 13 years. 2002 ଇଏ କେଶନ ଷ୍ଟାଇଲ ହଉଛି 2014 ମାନେ ପ୍ରାୟ 12 ବର୍ଷ ଖଣ୍ଡେ 11-12 ବର୍ଷ ଥିବ।
2002 ର occurrence.
So what happened? What happened to the others?
All total 9 accused person. Initially, 3 accused person was acquitted. Then, the present appellant along with another co-accused was faced trial, and he was also acquitted and convicted.
So 9 তিনটা convicted হেলে না কেতে total?
Initially 3 acquitted men.
How many face trial?
All total 5% face trial.
All total नहीं first trial रे केते जण?
First trial 3%.
All 3 acquitted. तापरे आपण आसिले बदे?
Yes ma'am.
Acquittal ପରେ आसिले.
No matter ST number 44/10. The accused person.
Yes, तो सब चेक करे
ୟାଙ୍କରଟା ହଉଛି 31/36 A of 2014 ଠିକ ତ?
ST 44 रे जजमेंट केबे हला?
Judgment my lord 2/8/11.
तापरे भी आइले नहीं.
Thereafter, there was ST number 31/31 by
3 ଜଣ ଫେସ୍ କରିଥିଲେ କଣ ହେଲା ତା ଦେହରେ? Acquittal ହେଲା.
Division minus one of the accused in the present case was absconded.
नहीं जो 3 ଜଣ ट्रायल फेस कले ST 44 of 2010 रे
they were acquitted.
So that is the first trial. Second trial कोटा? Second trial
ST number 31/36/14.
एटा
नहीं, it was A.
ओहो
ତା ଦେହରେ ପୁଣି ଆଚ୍ଛା
ପୁଣି ଆଉ ଥରେ abscond
The
କଲେ।
present accused is abscond since 13 years.
acha all right so by the way what is the evidence on record against the petitioner
PW1
nine accused persons including the present accused can been armed with deadly weapons Dangia Bhujali and Barsha searched for read it out that paragraph number 2 which you are just placing read it out.
Deeply from the FIR on 10/6/2002, at about 1:30 p.m., the informant Pushpa and Anwar had been to the house of the husbands of the elder brother, namely Chalan Anwar, who is the deceased of this case. The FIR revealed that at the time the deceased, who had gone to market, returned the home. At that time, 9 accused persons, including the present accused, came there being armed with deadly weapons like Tangia, Bhujali, Batsha, and searched for the Tipsan Anwar, who happens to the husband of the informant and brother of Chalan, the deceased. The accused, along with his associates, sought different place, disturbed the articles of the grocery shop, and directed the informant and wife of the deceased to produce Tipsan Anwar before them. In reply, the deceased stated Tipsan Anwar is absent in his house and ran away out of fear to OCL Loco Gate. Then the deceased, chased by the culprit who surrounded him in the land upon Lawrence Calcutta, and the deceased as well as the culprits were followed by the informant and his wife to the spot. It is further alleged in the FIR that the accused William, along with his associate, killed Chala by assaulting him with Bhujali and axe, which the culprit were armed by that time. Seeing the appearance of the culprit, the said two women could not dare to interfere for rescuing the deceased man.
Eyewitnesses are there.
Yes.
Who are the eyewitnesses?
PW1 and 2.
PW1 and 2. They have stated against you that you have assaulted.
Yes.
PW1 is the doctor,
No, man. 31 by
44 of 2000 रे doctor लिखा है
Yes.
ଆପଣଙ୍କର ଟ୍ରାଏଲ କୋର୍ଟ ରେକର୍ଡ କୋଉଟା ତାହେଲେ
PW3 ଟା ଡକ୍ଟର ନା
ନାଇଁ ନାଇଁ ନାଇଁ
ମାନେ ଯାହା ଜଣା ପଡୁଛି ଜଜମେଣ୍ଟ
ହଁ
PW3 minor doctor.
ହଁ
ନାଇଁ ଇଏ କୋଉଟା ଟ୍ରାଏଲ କୋର୍ଟ ରେକର୍ଡ କୋଉଟା ଖୋଲିଲା ତମେ
ଠିକ ନମ୍ବରଟା ଖୋଲିଛନ୍ତି ଟିକେ ଚେକ୍ କରିଦିଅନ୍ତୁ ଆଇଟମ 10 ଆଇଟମ 10 ର TCR ଟା ଫିଟା ଠିକ ଫିଟେଇଲା ହଉ ଦେଖିବା
ଅଛି ୱାନ୍ ଟା ଲେଖା ହେଇଛି ଡକ୍ଟର ପାଇଁ
ହଁ এটা ভুল ଅଛି আচ্ছা এটা ভুল LCR টা আসছে ফার্স্ট LCR টা পড়ে আসছে 44 of 2010 LCR টা
ନାଇଁ ନାଇଁ ଏଇଟା 44 ନୁହେଁ ଏଇଟା ହଉଛି ଅନ୍ୟ LCR
ହଁ ସେଥିପାଇଁ କହୁଛି ପରା ଏଟା 44 of 2010 which was the first trial ତା LCR ଟା ଆସିଛି
ଏଇଟା actually ହଉଛି
36 31 36A
31, 36 A by 40.
ସେ ଆଉ LCR ଅଛି କି ଆଉ ପଛରେ କାଳେ ଥିବ ଦେଖିବା 44 ଚାଲିଲା ନମ୍ବରଟା ଲେଖିଛନ୍ତି ସାଙ୍ଗେ କେସ୍ ଭୁଲ LCR ଟା କାଇଁ ଆସିଲା स्टेटमेंट भी से भूल पड़े जजमेंट भी ସେଇଟା ହେଲା ହେଲା ଆସିବ ଗୋଟେ ଅରିଜିନାଲ ଟା ବି ଦରକାର
ଟ୍ରାଏଲ କୋର୍ଟ ରେକର୍ଡ ଟା କାଇଁ ମଗେଇଲାନି ସେ copy of the trial court record is placed below ଲେଖିଛି but that is not the
କାଳେ ତଳେ ଅଛି
ଇଏ ଅଛି original file one job this doctor
ସେଟା ଠିକ ଅଛି
ନାଇଁ ନାଇଁ
ସେଟା ବି ଭୁଲ ସେଟା ଉପରେ ତ ଲେଖା ହେଇଥିବ ହଁ ଭୁଲଟା ଆସିଛି
ଏଟା ସେ ରେକର୍ଡ ଟା ମଗେଇନି ସେ
କେମିତି ଭୁଲଟା ମଗେଇଦେଲେ କି
ନାଇଁ ନାଇଁ ସିଏ ଟୋଟାଲ ମଗେଇନି ସେ ଦେଖିଛି କନେକ୍ଟେଡ ରେ ପଳେଇ ଆସିଛି
ନାଇଁ ତାହେଲେ କନେକ୍ଟେଡ ଅପିଲ କଣ ଅଛି କିଛି ତ ନାହିଁ
କନେକ୍ଟେଡ ଅପିଲ
अपील किसी तो देखो नहीं जो एफआईआर मैच किसी देखो नहीं
It was wrong FI. It was wrong record. जो थे लिखा होची Peter Barla and two others. Peter Barla की
44 वाला
44.
44 by 10
This is not the record. ଆଉ କିଛି ନାହିଁ record.
ଭୁଲଟା ପଳେଇଲା ଦେଖିଆ କଣ କଲ୍ ଫର ହେଇଛି ଆଡମିଟ ହେଲା
ठीक है.
କିଛି ଲେଖା ଖାଲି ଆଇଏ डिले कंडोन एडमिट कॉल फॉर
देखा ना हाई कोर्ट रिकॉर्ड चिट्ठी आई
चिट्ठीटा
ट्रायल कोर्ट रिकॉर्ड पे
सी मगे देले खाली सेमती एवढी पळेला ऑर्डर नंबर से कॉपी ऑफ टीसीआर स्पेस बिलो कोई चिट्ठीटा वाला जानी होनी ये वेरीफाई किए कल टीसीआर पाइला पर
तो वेरीफाई कर ले दीजिए ना
टीसीआर
जो ये पर ऑर्डर शीट पर अछि
हां टीसीआर रिसीव कर
टीसीआर रिसीव लिखो वेरीफाई करे माने
कॉपी ऑफ टीसीआर स्पेस बिलो डाकिले केबे किछ नै अपील नोटिस इश्यूड टू द appellant अच्छा हाँ कैसा थोड़ा फॉरवर्डिंग लेटर थ्रू आउ सेकेंड मैं ईमेल रे पठेथे
एथरे पठेथे तर गोटे कॉपी थिवो
कैड
डीलिंग असिस्टेंट किए
44 ଗୋଟେ ଜଜମେଣ୍ଟ ଟା ଫାଇଲ କରି ଦେଇଛନ୍ତି ତ ସେଟା ରିସିଭ ମାଗି ଦେଇଛନ୍ତି ଏଠି ସେଟା 11 ମାର୍ଚ୍ଚ ରେ ସେ ଜଜମେଣ୍ଟ ଟା ଫାଇଲ କରି ଦେଇଛନ୍ତି 44
डीलिंग असिस्टेंट को କହିବ हम लोग को रखियो डॉक्टर के पूरी करनी है डीलिंग असिस्टेंट किए थे ना डीलिंग असिस्टेंट और सुपरिटेंडेंट का we are passing it over
हां ठीक है केयरफुल होना पड़ेगा ना
तेरा वक्त ही करेंगे असिस्टेंट
वेरीफाई करना है ये कौन करते हैं कॉपी ऑफ जजमेंट भी जल्दी से सेटा देखि बजे जाते
ବର୍ତ୍ତମାନ କଣ ସେଇ ରେକର୍ଡ ବଦଳରେ ମାନେ ଇଏରେ ପେପର ବୁକ୍ ତିଆରି ହେଇଯିବ ଦେଖିଲା ବେଳକୁ ସେଇ ରେକର୍ଡ ୟେସ୍ ନେକ୍ସଟ
Item 11.
The accused is sentenced to for imprisonment under life and fine of rupees 10,000 under section
Madam, what is the year of practice?
2020.
2020. So it's a 302 case. So the court has appointed you as an amicus curiae, but as per the decision of the Honorable Supreme Court, a counsel should have at least 10 years of practice. For appointment the amicus curiae in life imprisonment case or death cases. So, are you aware about that decision? It is called Unauthorised versus Justice Lalit's decision is there. Next week, the decision the policy. You go through the decision. So that is consider Anokhi Lal versus something. You read it out that Anokhi Lal or something versus. Anokhi Lal versus Justice Lalit's decision that is.
State of MP.
Hmm.
Recently also that I think that one is also persisted.
ଯୋଉଟାରେ ଏ ଯୋଉ ପବ୍ଲିକ ପ୍ରସିକ୍ୟୁଟର କଣ୍ଡକ୍ଟ ଇଏ କଲେ
नहीं 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 सर Anokhi Lal रेफरेंस ଟା ଅଛି କି
ହଁ ସେଟା ଅଶୋକ versus state ର ମଧ୍ୟ ଅଛି।
Anokhi Lal रेफरेंस ଟା କଣ Anokhi Lal versus state of MP citation କହିଲେ ଏଇଟାକୁ କହିଲେ क्लिक करो SCC ऑनलाइन में citation बार दो find by citation report क्लिक करो SCC तौर का get the citation में 2019 लगा 2019 yes Mr. Jafarullah
20 SSC 196
volume 20
ଆଜ୍ଞା
20
SSC 196
196
ଆଜ୍ଞା
196 में क्यों देखा ही बैठता देखा जाऊंगी थोड़ा के तुम how to बड़ा scroll down करो थोड़ा how to पूरा complete डिस्काउंट रहा ये तो थोड़ा पकोना होगी that paragraph
Paragraph 22
22 इधर ऑन करो
ଅଲଗା ହେଇଥିବ
कौन आज स्टार्ट के दीजिए सेंटेंस का
sentence start with before we part we must lay down certain norms
पूरी बात पढ़ोला it is 31.1 in all cases where there is a possibility of life sentence or death sentence, learned advocates who have put in minimum of 10 years of practice at the bar alone can be considered to be appointed as amicus curiae, right? So,
if the accused himself engages, that is different.
that's a different. But for
in view of
amicus
the
curiae,
decision we can't.
Recently, shared copy.
Same thing.
Out
The role of public prosecutor was criticized. आप पहले compensation दिया था.
recently
Recently, Ashok versus
State of Uttar Pradesh. So versus state of
हाँ जजमेंट दियो लेकिन दोनों
पाइजोनी के
रेट यो अच्छी तो मैंने वो क्या सेटअप कर फाइंड इट आउट
उत्तर प्रदेश
এটা লিখতে না 2019 ভলিউম 20 SCC 196 Anokhi Lal versus state of Madhya Pradesh out ଦଉଛନ୍ତି
Ashok versus State of UP, criminal appeal number 771 of 2024.
777? Yeah. Edition ଗୁଡା ରଖିଥିବ ହେଲା ତ କେତେବେଳେ ଆପଏଣ୍ଟମେଣ୍ଟ ସବୁ ହେଇଯାଇଛନ୍ତି ବିଭିନ୍ନ କେସରେ ଅଶୋକ ଭର୍ସେସ ଷ୍ଟେଟ ଏଟା କେବେ ଡିସ୍ପୋଜ ଅଫ୍ ହେଇଛି ଜଣା ପଡୁଛି କି? କେବେ
2019, 2nd December 2024.
huh? 2nd December 2024 Ashok versus state of UP
Criminal appeal number 771
ସେ ପେଜଟା କାଢିଦେଲି ଅଶୋକ versus state of UP ରଖିଛି
Quoted in 2024, 12 SCR 55.
2012 24 12
12 SCR, Supreme Court report.
SCR
SCR.
page
335.
बेटा कौन बात करियो एससीआर बात करियो
हाँ से पूरा बाहर मन को मन बाहर अशोक versus
Ashok versus State of UP.
state of UP
बेटी आसो
ये बाला पर INSC ये बाला
INSC 919.
तादर कौन देइछि से विषय टी से
23 page अच्छा लास्ट को पढ़ा हाँ काढ़ दिन से पेज कंक्लूडिंग पार्ट रे काढ़ दो
तो दरकार
Para 23 G would be relevant.
कर देगी क्या कर देगी थोड़ी लगे पूरा जा रहा है
এটা অশোক This jail criminal appeal has been filed challenging the judgment and order dated 20th of January 2023, passed by the London Sessions Judge Sonpur in Sessions case number 59 of 2019 in convicting the appellant under section 302 of the Indian Canal Code and sentencing him to undergo imprisonment for life with fine of rupees 10,000 in default to undergo RI for 6 months. By order number 1 dated 26 2024, Ms. Aishwarya Das has been engaged as amicus curiae Learning Counsel has been engaged as amicus curiae. The Learning Counsel is present, and she submitted that our enrollment number is of the year 2020. He was enrolled as an advocate in 2020. In the case of Anokhi Lal versus State of MP reported in 2019-20 SCC 196, the relevant paragraph of quote कर दूंगी. In case of so and so, it has out of your assembly. In view of the observation made by the Honorable Supreme Court in the aforesaid group to decision, Ms. Das is disengaged as the amicus curiae. And in her place, so and so, Madam Jahu Koire.
ଆସିନଥିବେ ଆଉ। ତାଙ୍କର ଆସୋସିଏଟ ବୋଧେ କାହିଁକିନା ତାଙ୍କ ପାଇଁ ଟାଇମ ମାଗୁଥିଲେ ମିଷ୍ଟର ସାହୁ ଜଣେ ଅଛନ୍ତି ଯେ ସାହୁ
You are, please give the name.
Name, enrollment number.
Name and enrollment number.
Should I hand over the paperwork to sir?
Okay,
Yes.
sir. The paperwork which has been received by so and so, we handed over to so and so for them. Upon the is handed over for them. He handed over his vote to them. अब ये जो स्कैनिंग भी करिछन ये स्कैनिंग ହେଇଛି ସେ ଯୋଉ ଖଲାସ କେସର ରେକର୍ଡ ହେଲା
Maybe your lordship.
Yes, Mr. Ratho.
Well, the accused appellant has been convicted under section 302 ICC and 498 IPC and undergone sentenced to undergo RI for life for 302 and
You have
10,000.
given the deposition copy.
Yes, ma'am. Filed a small note to lordship government.
How many years after your marriage with the deceased?
2 years, 3 months. After 2 years, 3 months.
The cause of death is homicidal death.
Homicidal death, Miller.
No.
The cause is pressing of neck and chest and asphyxia due to pressing of neck.
How she died? You are paying your company. Within 2 months of marriage, he died. It's a homicidal death.
2 years, 2 months, man.
2 years, 2 months.
Yes.
All right. So, what is your explanation?
Explanation, actually, there is no material to show that there is any dowry demand. So he has been acquitted under Section 4 TP Act, 304B and 406 IPC. All father, mother and husband. Father, mother, without any assigning any reason, they are also acquitted for under Section 302. Only I have been convicted on a surmisation conduct. There is no motive. Motive has not been proved. Why there will be in one stage the learned session judge has read the evidence available on record is not sufficient to satisfy that harassment of the deceased was done with a view to coercing her to any persons related to her to meet any unlawful demand for any property and valuable security or is on an account. There is no.
Is it your case that you are not present in the house?
No.
What is your accused statement?
I say my statement that I do not know, man.
I do not know, then who will know? Because 106 of the Evidence Act in such type of cases is cast a burden on you that
actually,
how your wife died.
To be honest enough, Miller, the occurrence took place in a daytime.
Yeah.
In a daytime, and time of occurrence is not been proved. And the only thing that I have called my brother-in-law at 2 o'clock in the over telephone. So they have taken that is the point of time. That is the time of occurrence.
Are you staying with your family members?
Yes, I am staying with my family, father, mother, and my child.
No. What is the evidence on record? What is the evidence on record? Who has come first to the house? Who had seen the dead body?
So that is
where the dead body was lying.
Dead body was lying on the veranda.
Veranda. So, what the witnesses have stated that when they come to the saw the dead body, it was lying on the veranda.
No evidence to that effect, my lord. Therefore, my lord, to convict me, my lord, at least the pressing of neck is there. My palm or fingers, those have been measured to just correlate to that injury. That has not been done. Even my nail clippings, etc., has not been taken to examine. I have not been examined by medically whether there is any injury on me because of struggle or anything else, my lord. That is why I have given that small note, my lord. These are the circumstances they have considered, and these are the circumstances they have not considered.
No, we are hearing a bail application.
Yes, my lord. That is the circumstance. The bail application, my lord, that is
not on merit of the case. So, detailed examination of the evidence, and if we give some findings, it is likely to have an effect at the final adjudication of the appeal.
I do admit, my lord.
So, we are not going to enter into that. Just by the way, we ask you a few questions, and it's all right that you have prepared a written note.
No evidence regarding dowry is not there, but drinking liquor and assaulting your wife, PW6.
PW3265, they're continuous.
That is that evidence. That is my
Evidence means?
Session judge has observed that is a continuous
No,
misbehavior to that.
no, we have to see if they have given evidence.
There is
or
no
not.
evidence to that.
Means they have not stated.
No evidence, madam.
What do you
What
mean by
evidence?
evidence?
Evidence,
The
madam.
witnesses have stated
That
that
is not evidence.
you were assaulting your wife after taking liquor for which the village meeting was convened, and in the meeting you were advised not to do all these things. So, and the deceased was also
And PW8 says after a girl child was born, you drove her out of the house.
yes.
There was a
When
village meeting.
when the meeting was organized, held, and you took the wife with you, assurance was given.
Commissioner, kindly see PW 14 for a minute.
PW
14. That is a doctor. That shows how many injuries are present in the person.
No, that is there. So multiple injuries are there.
PW 3, 4, 6, 8. This is a and PW 9, the consistent evidence that she was meted out with torture and everything. And immediately after the death of the deceased, appellant telephoned the relative of the deceased and played it.
PW3, PW4, manner they have been. PW3 has been declared hostile.
As it appears, she was assaulted, for which she sustained number of injuries. Thereafter, the neck was pressed, and the cause of death was due to asphyxia as a result of constriction of neck by means of manual pressure.
Yes, madam. That doctor says, your lordship may see evidence of Dr. Miller. PW14.
Yes.
May I place the evidence of PW 14?
We have already seen
paragraph 6, your lordship, miss. Paragraph 6. On 14/7/2021, I was in same post. On that day, I received query requisition from IAS Sadar PS Balangir with relevant document. After query, I opined that the injuries mentioned in PM report were antemortem in nature and injury number 1 to 7 were caused by compression by means of hand. The manner of death was homicidal in nature and fatal to the cause of death is there. Cross-examination, paragraph 7, madam. I have not noticed any finger mark or injury of nail mark on the neck of deceased during my autopsy. In one stage, there is a pressing of neck by hand. The next paragraph is say, I have not noticed any.
No, nail যদি ବାହାରି ଥିବ ଇଏ ହବ ଆପଣଙ୍କ ପ୍ରେସ୍ ଯଦି ଏମିତି ହବ ତାହେଲେ ନେଲ ମାର୍କ କାହିଁକି ଆସିବ ଆପଣ ଜଣକୁ ମାରି ମାରିକିନି ତାକୁ ପୁରା ଅଧମରା କରିସାରିଲେଣି ତାପରେ ତାର ଗଳା ଚିପୁଛନ୍ତି ଆଉ ସେଠି
ଗୋଟେ ଏପଟେ ବି
ଯୋଉ ଟାଇପର ଇଞ୍ଜୁରି ଅଛି the number of injuries which he has sustained on different parts of the body.
Those are all simple injuries.
No, simple injury.
But that is facial injury, that is the specific evidence of the PW 14 units.
Ultimately fatal. The aguru simple all over.
Yes.
3, 4, 5, 6, 7, 8, all there are simple injury bluish.
That means everybody's wife will sustain simple injuries as a matter of course.
Ultimately, she died.
The reason is not there. Once the conviction under section dowry torture is gone, my lord. 498.
No, we are in 302.
No, that 498 is there for
302, 106, and you are the husband.
302, my lord.
No, you mean to say that wherever in a case of circumstantial evidence, the motive is not proved, but otherwise the case has been proved. The
case is proved, my lord, I cannot say.
How do you discharge your burden under 106? Plain and simple question. Your wife was staying with you and she has sustained these injuries. Case is homicidal death, neck pressing, and previous incident was there that you were assaulting the wife, torturing her. She had gone to her parents' house, a meeting was held, and you give assurance and brought back your wife to you and you are staying, then this thing happened. So how do you explain it?
Small child, my lord. 3-4 years now.
The mother is dead.
Mother is dead. Nobody,
Where
no
that child is now?
No, nobody else is there to take care of.
That you don't take care. Because after
Okay, with us,
the daughter was born, the assault started.
That was the reason, since it was a
So
female
now
child.
motive you have.
You are expecting a boy or what? Now it
ଆମର
is.
ତ ସରିଗଲାଣି ଆଉ 2-3 ମାସ ପରେ ସରିଯାଇଛି ଆଉ କଣ କରିବା ବୟ କୋଉଠୁ ଆସିବ
So
ଆଉ ବୟ କୋଉଠୁ ଆସିବ ତ ମଦର ଇଜ ଡେଡ୍
no, you are
You didn't hear the question.
you are expecting a boy.
ନାଇଁ ସେଇଟା that is also not in evidence madam.
PW8. After 1 year of her marriage and blessed girl child, her parents-in-law and husband demanded dowry and drove her out from the house at night. After receiving telephone call, he went to the house and called gentries of the village to convey a meeting.
Entire prosecution said only for dowry, nothing else.
No dispute. Some witnesses have stated dispute. Some may have stated dowry which was not accepted.
Apparent 7-6 arrest on 9-6.
Or the learning counsel for the petitioner, learning counsel for the state. Mr. Ratho, learning counsel for the petitioner, submits that the petitioner, along with his family members, face trial for commission of offences under section 498A, 302, 304B, 406, by 34 of the Indian Penal Code, read with section 4 of the Dowry Prohibition Act. And the London Trial Court has acquitted the co-accused persons of all the charges, so also the petitioner of the charges under section
304B and
304B and 406, reduced section 4 DPR. Are found in guilty under section 498A and 302 of the Indian Penal Code. It is further contended that in view of the acquittal of the petitioner of the offences under section 304B and 4 DP Act, the motive behind the commission of the crime, that is demand of dowry, has not been established. The Land Council submits that the doctor bracket PW
14
PW 14, though stated that the cause of death was asphyxia as a result of constriction of neck by means of manual pressure, but in the cross-examination he has stated that he has not noticed any finger mark and injury of nail mark on the neck of the deceased during the autopsy, and that finger mark and nail injury on the neck of the deceased is possible in case of manual compression of the neck. The Land Council submits that in view of such evidence of the doctor, there are good chances of success in the appeal, and the petitioner is already in custody for about 4 years.
4 years.
4 years, and he has a small child to be taken care of, and therefore the bail application may be favorably considered. Land Council for the state, on the other hand, opposed the prayer for bail and submitted that number of witnesses have stated how the petitioner after taking liquor, was subjecting the deceased to physical and mental torture, for which she had left her matrimonial house, and subsequently village meeting was convened to settle the dispute, and thereafter the uh, petitioner was advised uh, to take the deceased with him, and then this occurrence has taken place. And as per the evidence of the doctor, number of injuries on different parts of the body are noticed apart from the injury to the neck, and the petitioner has, though was staying with the deceased, has not offered any explanation as to how the deceased died a homicidal death. Considering the submission, and therefore the bail should not be granted. Considering the submission made by the land counsel for the respective parties, the relationship between the appellant and the deceased, the manner in which the crime has been committed, the post-mortem report finding, and the background of the case, we are not inclined to release the petitioner on bail according to the bail application stands rejected. Yes,
May I
next.
renew it for some.
You are at liberty to read. Yes, next.
Item 13.
The plea units. The appellants were convicted under section 30234 of the IPC and sentenced to arrest for life units. The appellant number 2 and 3 are son of appellant number 1 units. Initially, the affair was registered against 5 persons. Father, mother, 2 sons and daughter units. And charge sheet filed against father, mother and 2 sons. And trial court convicted the father and 2 sons units under section 302 and 34 IPC.
So eyewitnesses are there.
Yes, Lordship.
5 eyewitnesses, sir.
So what they have stated, tell us one eyewitness.
My
who
lord,
is-
1,
I'm
5,
listening
6,
first
8
to
and
the
10 units.
affair.
No, just what eyewitness. PW,
PW6, your lords.
just a minute. PW6 is the eyewitness.
My lord.
And who is the doctor?
PW14.
PW14.
No, 19 would be relevant. 19 is the postmortem doctor.
Acha, PW19 is the doctor.
Yeah.
So who is 14?
14 was a.
Oh,
This is a
examine first there, then he
injured.
died. So when the occurrence took place?
Occurrence took place on 10/3/2018 at about 9 p.m.
10/3/2018.
My lord.
When he died?
That on 11/3/2018.
Acha, death the next day.
My lord.
11/3/2018. So let us come to PW6, see that how the occurrence has taken.
My lord, I know the informant, who is my younger brother. I know all the accused persons present in the dock as well as accused Supapati Port. I also know deceased CORAM Pandey. The occurrence took place on 10/3/2018 at about 9:30 p.m. in front of our house on the village Dando. At the time of occurrence, I was standing in my outer courtyard after taking food. By that time, I heard shout as Marigali, Marigali. When I came to the spot, I saw the accused Madharpur was assaulting by means of crowbar on the head of the deceased. Accused Sagarpur, Surupur, and their mother Sukhavati were assaulting him by means of thenga. I called my parental uncle to prevent the accused persons from further assaulting. Tonkamari Pandey, Jataram Pandey, Balaram Pandey, and Bankaram Pandey arrived at the spot and requested the accused person not to assault, but they were declaring to take away
Okay, so come to the doctor's evidence. PW19.
On 11/3/2018, I was working as senior resident in Department of FMT Bhimsar Bulla. On that day, after receiving police requisitions from Bulla PS
by case number so and so, I conducted post-mortem examination over deceased Tankaram Pandey, son of late Krishna Chandra Pandey, resident of village Panjari, yes, Bolangir town, district Bolangir, being identified by Constable so and so on external appearance post-mortem, repeatedly fixed on back figures, motif detected on upper half of the body. There is bleeding seen from nostril and pure dew straw found sticking to the scalp hairs. And
Since when you are in custody?
alert. Alert. All the appellants arrested on 12/3/2018, but the appellant number 2 and 3 were on bail during trial, Your Lordship.
So the so far as out of the 3 appellants, the allegation is that this number 1, Mayadhar, who was the father of 2 and 3, he was holding a crowbar. The others were holding lathis. And as per the evidence of PW6, Maya assaulted first on the head of the deceased, and others assaulted them. So the doctor has noticed PW19 that the head injury is there, and cause of death is also due to head injury.
PW14 also saying so, Your Lordship. The first doctor
Craniocerebral injury and its complication. Petitioners Land Counsel for the state. The Land Counsel for the petitioners submitted that appellant number 2 and 3, namely Surupur and Sagarpur, were on bail during trials. And so far as the evidence of eyewitnesses are concerned, the overtake that has been attributed against appellant number 1, Mayadhar Ford, is that he assaulted by means of a crowbar on the head of the deceased. But so far as appellants number 2 and 3 are concerned, the statement are omnibus in nature. The Land Council further submits that the doctor bracketed PW19 who conducted post-mortem examination has noticed the injury on the head and opined that the cause of death was due to craniocerebral injury and its complication. Submits that since there is no chance of early hearing of the appeal in the near future, the bail application may be favorably considered. And Counsel for the state submitted that apart from PW6, who are the other eyewitnesses?
1, 5, 8, and 10.
PW1, 5,
8, and 10.
8 and 10 are the eyewitnesses to the occurrence, and all of them have specifically implicated the appellants in the assault of the deceased. Considering the submission made by the Land Council for the respective parties, the nature of overtake attributed against the appellant number 1 and the evidence of the doctor who conducted post-mortem examination, we are not inclined to release appellant number 1, Mayadhar Swansu, on bail. Accordingly, the bail application stands rejected. So far as appellant number 2 and 3, namely Swansu are concerned, taking into account the omnibus nature of role that has been stated to have been played by them, and the fact that they were on bail during trial and there is no chance of early hearing, we are inclined to release the appellants number 2 and 3 on bail. While on bail, they shall not indulge in any criminal activities. Violation of any terms and conditions shall entail cancellation of bail.
Minus to the year and 36. This year, any day, convenient. I don't know 36. Only this year, the third salary. I hearing list of kind.